want to try it? Give it a try?
Yeah.
It looks like you could move it over to the right.
No, that's fine. She's like, it's the Mickey Mouse Club. Sound off now. Yeah, dating myself. She probably goes, Mickey Mouse Club.
Yeah, that's going back.
But there was
I think there was a new one, right?
With Britney Spears and Justin Timberlake.
Well,
yeah.
listen to you,
Mickey Mouse Club?
Mr. Curran.
It's not a group.
I always talk to my students about that. You have to watch what's currently going on social media so you can be relevant for your jury when you're doing jury selection.
Good for you. I couldn't do it.
Well, that's why as you get older, you start doing questionnaires. Have somebody else write them for you.
Yeah.
That's why they're putting it on here too. Somebody was doing that early on anyway. Some of the first appearances, they put it on. I said everybody has different models of what. Confusing.
Yeah. It's like a light blue. I don't think my fever got that.
The one that she told you.
Yell at me. Yeah.
Not feeling great. But that was it. I didn't have any bad one or anything.
We'll find out. We have some questions. Who goes first?
Who goes last?
I think everybody that I know lawyers.
It's like baseball routine. Have it because
Yeah, right. You know that's on a continuous loop at Cooperstown? Yeah. One of the exhibits, sort of a locker room, and it has that playing on a continuous loop. Or it used to.
one of those other things that's amazing about those guys, during the 40s, they had their own radio show. They did a modified version of that every single week.
Really?
So it would be about, gardening or baseball or whatever. Just how you kept up with the timing on that was just amazing.
Is it still a thing if you have a medical condition and you can't wear one? Then you're supposed to wear a shield. No?
She's getting better. She couldn't be here today. She sent her daughter.
So
Muted is why you should not be able to taste things. Oh wow. I didn't know what a puppy. What breed? Did they still make you pay for it?
You could put it in the journal.
There were 3 left. And 3. 3 are crazy. There's this presumption.
That's have to carry it over every day. I got a spare if we need one. I said I have a spare if we need one.
Okay.
Folks in the audience, just want to be clear that everybody behind the bar has to be wearing a mask, okay? The attorneys are exempt only because they need to communicate with the judge. All right? Sir, in the back, you need a mask?
Did they say
do math. It's a red disc. You cast down from 60. So you can see how the disc gets smaller. Tells you how you're doing on time.
All right.
Calling the habeas petition in the matter of Scott V. Peterson versus the people of the state of California. Appearances, please, starting with counsel for petitioner. Thank you.
Good morning, Your Honor. Cliff Gardner for petitioner Scott Peterson.
Good morning.
Good morning, Your Honor. Andres Vargas for petitioner Scott Peterson.
Good morning.
Good morning, Your Honor. Patterson on behalf of petitioner Scott Peterson.
Thank you. And the record will reflect that Mr. Peterson is present in the courtroom for a respondent, the people.
David Harris for the people.
Birgit Flatiger for the people. Victoria Vasquez for the people.
Thank you. All right, before we begin, this is on for our oral argument of the petition and the evidence in the record. But before we begin, this matter is being live streamed on the court website, and just so that the public knows, members of the public are prohibited from California Rule of Court 1.150 for recording this stream without prior order of the court. That does not apply to media that received an order from the court, but it does apply to the public. Very well. The court has received and reviewed the briefs by counsel and the reply briefs. I may have some questions as we proceed today, but counsel, when you argue, you may take off your masks as well. For everyone else in the public, please keep your masks on. There is a mask requirement in San Mateo County, so while you are seated in the courtroom, please keep your masks on. But for counsel, you may take your masks off when you are providing argument to the court. Mr. Gardner.
Good morning again, Your Honor. It's nice to see that we're all here and all healthy this time.
Correct.
It is, yes. Your Honor, as you may recall, before we had the evidentiary hearing, a few weeks before, there were some hearings on pretrial motions that the parties had brought. And one of those pretrial motions involved the appropriate burdens of proof that the court was to apply in this case. And the court issued a ruling in connection with those motions on February 15th. And what the court said was that there were two distinct burdens. One was an initial burden on petitioner, Mr. Peterson, to prove the existence of jury misconduct. And what the court said, and that had to be proven by a preponderance of the evidence, is that petitioner's burden was to prove a juror had concealed relevant facts or given false answers during voir dire. That was the initial burden placed on petitioner. In the situation where petitioner satisfied that burden, the court went on to note that the burden would shift. There would be a presumption of prejudice, and the burden would shift to the state to establish that that misconduct was harmless. That seemed like a good framework to me then, and it still seems like a good framework to me, Your Honor. And so I thought I'd tailor my relatively brief remarks this morning to those two burdens, whether we've established our initial burden of proving misconduct and whether the state has carried its burden, assuming we have proved misconduct, of establishing that the misconduct was harmless. So let me start with the first question, and that is, did we carry our burden by a preponderance of the evidence of proving the existence of jury misconduct? And I have to say that before we get to the merits of that question, Your Honor, there is sort of a nuanced legal disagreement between the parties. The petitioner's position is very much allied with what the court said in its February 15th ruling, which is that to carry our burden, we have to prove that a juror has concealed relevant facts or given false answers during voir dire. The state takes a slightly different position. The state's position is that that predicate finding of misconduct is not established simply by the proof of false answers or concealment. but that petitioner, in order to establish his burden, has to also prove that those false answers were intentional. And I just want to take a quick moment, I know this is in the briefs, to say that I believe the state's position cannot be squared with either the language of Manriquez from the Supreme Court or the holdings of Manriquez, Cowan, and Boyette. And I'll just take a moment. Manriquez was a relatively recent 2018 decision of the Supreme Court, where the Supreme Court talked about how a, quote, a juror who conceals relevant facts or gives false answers during the voir dire examination undermines jury selection and commits misconduct. And then they went on to say such misconduct includes the unintentional concealment, that is, the inadvertent non-disclosure of facts. And so I don't know how the court could have been any clearer to say that the inquiry into intent, which is an important inquiry, and we'll talk about it, I think, in connection with whether the state has carried its burden of rebutting the presumption of correctness, that is not a part of petitioner's initial burden.
So, question, Mr. Gardner, how do you reconcile that statement with a false answer?
Well, falsity is going to be determined in some objective sense, and we'll talk about it in a moment in connection with some of Ms. Nice's answers. But let's say, for example, a juror gives a false answer and it's unintentional. We know from Boyette, we know from Manriquez, and we know from Cowan that that's still misconduct. That's why each of those cases found unintentional false answers, but they went on to impose a presumption of correctness, a presumption of prejudice, and they resolved the case by analyzing whether, in fact, the state had rebutted the presumption. Now, obviously, if there had been no misconduct to begin with, there's no need to analyze whether the state has rebutted the presumption. Those cases, I'm sorry. Oh, I'm from New York. That's going to be very difficult to do, but I will try.
And particularly when you read,
yes,
Mr.
okay.
Gardner, if you could slow down. Both the court reporter and I would appreciate it. Thank you.
Well, the court will be pleased to know there isn't much more reading in at least my prepared remarks. So I don't believe that the state's position can be squared either with the language of Manriquez or with the fact that Manriquez, Cowan, and Boyette all went on to resolve the case by looking to see if, in fact, the presumption had been rebutted.
All right, if I could interrupt for a moment. Madam Clerk, can I get this pen does not work, and I'm using a red pen. Thank you. You may proceed.
So that brings us to the merits of whether, in fact, petitioner is established by a preponderance of the evidence that misconduct occurred, that false answers were given or facts were concealed. And I want to focus the court's attention today. Obviously, we briefed all the aspects we believe constitute misconduct, and the court's read that briefing. I want to focus today on two questions in the questionnaire. Questions 54 and question 74. I'm sure those come as no surprise to the court that I'm focusing on those. Question 54 was the question that asked, have you ever been involved in a lawsuit? And Ms. Nice answered in the questionnaire, no, I haven't. And in fact, we now know that that was false, that she was involved in two lawsuits, a restraining order lawsuit in 2000 and a civil damages lawsuit sometime thereafter. How do we know? We know because Ms. Nice has told us. Exhibit 1 of the exhibits that were introduced, Your Honor, is the paperwork for the restraining order litigation in November of 2000 and December of 2000. It's handwritten, and in her testimony at the evidentiary hearing, Ms. Nice conceded that, in fact, she was the one who filled out that paperwork and filed that action. I believe there's also a declaration from Ms. Nice in evidence. I think it's Exhibit 10, and in paragraph 19 of that declaration, Ms. Nice admits that, in fact, she was the one who brought that action. So I don't think there's any real dispute as to whether, in fact, she was involved in a lawsuit. She was.
Well, but let's go back for a moment.
Sure.
Lawsuit is a term of art. You agree?
Well, it can be a technical term. I do agree.
Technical term. And not everyone has the same definition of a lawsuit. Your definition of a lawsuit and my definition may be very different from someone who, a member of the public who has never been in a court of law. Agreed?
Agreed.
Okay. So, isn't it, jury questionnaires are they have their place. I think we all agree. And it's used to determine whether or not, just based on the answer, someone could be a fair and impartial juror in a case. So there is a process by which the questionnaire is used to eliminate individuals who really, based on their answers, could not sit as a fair juror in a particular case. Agreed?
Agreed.
Okay. But the terms that are used are the terms that are crafted by the attorneys and sometimes the courts involved. I don't know in this case if a trial judge was, but those terms are, the words used are generally generated from the attorneys. Agreed?
I'm sorry, they are?
They are generated in the questionnaire by the attorneys.
Yes, they are.
Okay. And would it not be important then for the attorneys during the actual voir dire to clarify? If a lawsuit may have different meaning, and it is important to determine if someone was involved in a restraining order proceeding, one, you either ask the specific question in the questionnaire, agreed?
That could be, certainly.
Okay, or you follow up during the questioning of the particular juror.
Also true, that could and should happen as well.
Okay, there was no follow-up in the record in this case by Mr. Garagos about what the term lawsuit meant, correct?
That's true.
Okay. And so, and he didn't ask Ms. Neese whether or not she had ever been involved in a domestic violence proceeding or a restraining order proceeding, correct?
Correct.
Okay. So, again, and I'm going to ask the people to respond to this. Is there any relevance to that for this court's determination on the habeas? If so, tell me how the court should handle that information or the absence of the information in this proceeding.
Sure. And of course, I'm going to say there is relevance. Mr. Dave Harris, I would never put words in his mouth. He's going to tell you that there's no relevance. Here's why I think it's relevant, and it gets back to the initial point I made about when the inquiry into intent matters.
Okay.
If that answer is false, regardless of whether it was in a good faith belief, the good faith or not good faith of that answer, that no, I haven't been involved in a lawsuit, is false. That is the answer, no, I haven't been involved in a lawsuit. The reason we know it's false is because, in fact, that restraining order litigation is a lawsuit. How do we know that? The state has conceded it. In its informal reply in the state Supreme Court, at page 27, the state gave it a good definition when they said, yes, in fact, this is technically a lawsuit, because a lawsuit is defined as a dispute that's given to a court for resolution, a process by which a dispute is resolved by a court. That's a lawsuit. That's what this is. Now, Your Honor's question, and I understand the series of questions Your Honor asked me and where you're going with this, and it is relevant whether her answer was reasonable, that I didn't think it was a lawsuit because it didn't involve money. And we'll get to that when we talk about prejudice. But in connection with the predicate question of misconduct, that answer is false. She was involved in a lawsuit. In fact, the state, I think at pages 33 and 53 of its opening brief, concedes that her answer was, quote, erroneous, end quote. There may be some daylight between an answer that is, quote, erroneous, end quote, and an answer that is false, but I'm not seeing it. I'm sure Mr. Dave Harris will explain the chasm of daylight that there is between those two. But the recognition that, in fact, this answer was erroneous, based on an erroneous understanding of the word lawsuit, I think comes very close to conceding that, in fact, juror misconduct has occurred because the answer was false. But even putting aside the restraining order litigation for a moment, Your Honor, there's the civil damages lawsuit. Again, how do we know that she was involved in a civil damages lawsuit? We know because Ms. Nice told us she was. She told us she was at pages 42 and 43 of the evidentiary hearing, and again at page 291. She recalled filling out the paperwork, filing it in court, coming back to court, and dismissing that lawsuit. And she talked about the fact that it was for damages for lost wages. So we know that she was involved in at least 2 lawsuits. Now, the state's position, we talked a little bit about their position as to the restraining order. The state admits that this restraining order was, the answer in connection with the restraining order was erroneous. To me, that's a tacit admission that it was false, and that means misconduct has occurred. Mr. Dave Harris will undoubtedly disagree with my construction of that, but that's our position. With the civil lawsuit, they have a slightly different position, Your Honor. Their position, and Mr. Harris accurately notes, that we didn't provide any documentation of that civil lawsuit. This is at their state's reply brief at pages 7 to 8. And that's true. But that's not the burden on petitioner. The burden on petitioner isn't to provide documents. The burden on petitioner is to establish by a preponderance of the evidence the existence of a lawsuit. And we actually have a slide. Petra, if you would be kind enough to put that up. Here's what Ms. Nice testified to in connection with that lawsuit. I don't know if Your Honor can see that.
I can, thank you.
So is this a question by Mr. Pat Harris? You filed a lawsuit against her for, I believe, lost wages and a number of other things. Is that answered by Ms. Nice? I did. Yeah, clearly I misled the court when I said there'd be no more reading. Question by Mr. Pat Harris. Okay, and so the incident you're describing when you came in and told the judge to dismiss, you're referring to the civil lawsuit? Answer, yes. And at page 291 of the evidentiary hearing, there's similar recollection by Ms. Nice, a little more detailed about the fact that she filled out the paperwork and filed it. So there should be little genuine dispute as to whether Ms. Nice was involved in lawsuits. And that, I think, covers question 54. The other question I'd like to cover in terms of the jury misconduct burden, Your Honor, is question 74. That was the question that asked, it was a sort of a compound question. Question 74 asked Ms. Nice, have you or any close friends or any relatives been the victim or witness of a crime? Give me a moment, Your Honor. I am well recovered from COVID, but still have a raspy throat.
That's all right.
So, we're talking about question 74, which asks whether Ms. Nice had been the victim or witness to a crime, or her friends or her family. I'd like to focus on one aspect, one of those permutations. I think all of them are covered in the briefs, but I'd like to focus on one of those permutations here, and that's the question of whether Ms. Nice herself was the victim of a crime and didn't reveal it. And there are two different incidents, as I'm sure the court is aware of where I'm going. The first is the 9/23 incident with Ms. Kinsey, and the second is the potential domestic violence incident a year later with Mr. Whiteside. In terms of the 9/23 incident, which I'll start with, the court needs no detailed discussion of the facts. You heard all the testimony. Basically, Ms. Kinsey shows up at Ms. Nice's house screaming for her to come outside so they can fight. Ms. Kinsey then slashes Eddie Whiteside's tires. She kicks the door into Ms. Nice's home. She then leaves. Subsequently, in the subsequent weeks and months, Ms. Nice moves. Ms. Kinsey finds out where she is. She calls her several times on the phone and hangs up. She says she wants to settle it on the streets, and then one day she follows Ms. Nice in a van to her place of work. That's basically the facts involving the 9/23 incident. And so the question is, was Ms. Nice the victim of any crimes in connection with that incident? And I'll start with the door smashing incident. I believe she was a victim of a crime in connection with Ms. Kinsey kicking in the door, and I believe Ms. Nice told us so. I think we have a slide here as well, Petra, if you'd be kind enough to put that up. This is Mr. Pat Harris asking, she, Kinsey, kicked in the front door of your house. Is that correct? Answer, she did. Question, did you consider that to be a crime? Answer, yeah, sure. So it was a crime, and it was a crime against her, and she's admitted it. And yet, in the questionnaire, when asked, have you ever been the victim of a crime, she said no. What about the stalking? The component of the 9/23 is where she comes screaming to the house, she kicks in the door, she finds out where Ms. Nice has moved, she calls her, hangs up, we're going to settle it on the streets, follows her in a van.
And Ms. Kinsey is Mr. Whiteside's former girlfriend.
That's correct.
And I believe Ms. Nice's testimony was that when Ms. Kinsey came to the house and kicked at the door, she went upstairs and told Mr. Whiteside, I'm not sure if she said your girlfriend's here, but she left it to him. She didn't remain downstairs.
Correct, I think that's right.
Okay.
But the stalking has a sort of a broader component to it. It's not just what happened that night, but it's the tracking her down, calling her and hanging up, calling her and saying, we're going to settle this on the streets, and then following her in a van. And the question is she the victim of the stalking? And I think, again, Ms. Nice has told us that she was. And this is I think, page 57 of the transcript. Do you consider her stalking you to be a crime? Answer, sure. So we can debate it, but Ms. Nice didn't debate it. She was the victim of stalking. And I think,
Well, but if you look at the question, do you consider her stalking you to be a crime? Do, as in the present day, not did. The last question was did. This question is do. I don't know if that's a distinction without a difference to you, but in other words, today, looking back, and do you consider what she did back then to be stalking is different from did you consider it at the time?
it is different. And so, for example, there could be a change in that time period. In 20 years, I suppose, society could have a different view of a particular course of conduct, where it wasn't considered criminal at one point, and now you realize, now I realize that what happened to me was criminal. That's sort of like what happened in Rodriguez. But this is not that. Back in 2000, we all knew what stalking was. There was a stalking statute, and this behavior fits squarely within that stalking statute. Moreover, what we do know, Your Honor, is that Ms. Nice also testified at the evidentiary hearing that but for the continued conduct, not just the incident where she kicked in the door, but for the continued conduct, she would never have sought the restraining order. So clearly at the time, she thought there was some danger inherent in what Ms. Kinsey was doing, or she wouldn't have told us under oath that the only reason she sought that restraining order is because of what happened after the 923 incident. So I think you're right, the tense of the question may raise an ambiguity, but I think Ms. Nice's remaining testimony resolves that ambiguity.
All right.
Okay? So let's talk a little bit about the domestic violence incident. That's November of 2001. This isn't quite so easy on petition, I think, in terms of whether Ms. Nice is admitted or not, because as Your Honor will recall, she quite plainly and explicitly denied it. So we have two versions of this event. We have the version that's informed by the contemporaneous documents that were admitted at the hearing. That's Exhibit 2, Exhibit 8, page 3, and Exhibit 23. And these documents tell this following story. They tell a story that on the evening of November 2nd, 2001, police were called and they arrived at Ms. Nice's residence.
You want to slow down?
I'm sorry, Madam Court
That's all
Reporter.
right.
This will slow me, Your Honor.
Okay.
So on November 2nd, 2001, police arrived at Ms. Nice's house late in the evening. Mr. Whiteside is arrested and charged with 5 crimes. He's charged with battery on a spouse, corporal injury to a spouse, false imprisonment, endangering the health of a child, cruelty to a child, and simple battery.
Who called the police that night?
Good question. I think in the evidence, Ms. Nice has said that Eddie Whiteside called police.
Okay.
Okay? So police show up, they arrest Mr. Whiteside, charge him with those 5 offenses. We know from the remaining exhibits that, in fact, he pleads guilty to battery, and the other charges are dismissed. And we know he's ordered to serve, I think, 10 days in county and 104 hours of domestic violence counseling. So we have that version told by the documents. Ms. Nice has come into court 21 years after the incident and said that, in fact, those documents are wrong. There was no domestic violence. Here's the version she gives. She says that on the evening they argued. They argued over, I think she said she believed it was over the fact that Eddie was cheating on her. They argued, they came into the house, she was carrying the baby, she gave the baby to her mom, she closed the bedroom door, and then she started hitting Eddie Whiteside, and he never hit her. That's her testimony.
Right.
Now, the question is, which one is a credible version? I don't believe the court has to resolve that for purposes of misconduct because of questions 54 and some of the things we've already discussed. There are false answers given. But let's go on, let's proceed down this road. Which of those 2 versions is correct? The version told by the contemporaneous records or the version Ms. Nice gave 21 years later? And I think there's a number of reasons, 4 reasons in particular, to question Ms. Nice's 2022 testimony about what happened and to credit what, in fact, the documents show, the contemporaneous documents. The first is that Ms. Nice at the evidentiary hearing testified that although Mr. Whiteside was stone cold innocent, she never offered to come forward and tell anyone that. Not the DA, not police. She never told anyone that he was innocent until testifying in court.
I believe her testimony was that the police officer who was at the scene asked her about a bloody lip. And that at the scene, she told the police officer, and she didn't even know she had it, but it was because of braces.
That's true.
And that she did not know Mr. Whiteside had even suffered a conviction until recently. As part of this proceeding, she learned it, but she didn't know back then.
My recollection of the record is a little bit different. My recollection is that she saw police take Mr. Whiteside away that night.
Well, it's seen someone take, I agree with you, but that's different from he was convicted of domestic violence.
That is different, but she also testified that she knew he was arrested.
Right?
Okay, so let's scale it back. She knew he's taken by police that night. She knows he's arrested. She doesn't come forward and say anything. More importantly, perhaps, is that Eddie Whiteside never asks her, according to Ms. Nice, to come forward. Now, regardless of what Ms. Nice may have known or not known, Mr. Whiteside knew he was charged. And if, in fact, her version is correct, that is, she handed the baby to her mom, the mom's outside, she closes the bedroom door, she starts hitting Eddie. Eddie would have known that he was innocent, and Eddie knew he was charged, and Eddie knew what he was facing, jail time. Eddie would have asked her to come forward. Ms. Nice, Rochelle, tell them what happened. Tell them the truth. And yet, according to Ms. Nice, Mr. Whiteside never asked her to do that.
Well, okay. So the record, as the court remembers it, and I will go back, was that on that evening, when the police arrived, Ms. Nice's testimony was that she actually used an expletive to the police and said, "I'm not cooperating. Get out. I'm not letting you in." And she went back up, either went back upstairs, but she didn't open the door for the police. Agreed?
Well, she was certainly resistant and used expletives when police arrived.
Okay.
I don't recall who actually opened the door, but yes.
All right. And so how should the court view that? In what you're saying, that I should believe the records and what happened versus Ms. Nice's version on the stand about
Well,
what
if I understand the court correctly, the court's concerned that Ms. Nice may have not known he was arrested for domestic violence that night, and so that she wouldn't have had motive to come forward.
Correct.
Let's assume that's correct. She didn't know that night that he was arrested for domestic violence. They were living together. At some point, she must have known that he was arrested for domestic violence. But let's put that aside. Eddie Whiteside knew he was arrested for domestic violence. And according to Ms. Nice, he never even asked her to come forward and tell the truth. So regardless of what she knew in terms of whether he was arrested, and I think she did know he was arrested that night, Your Honor can say, well, she might not have known the charges, and perhaps that's true. But Eddie Whiteside certainly knew the charges. And if he never asked her, at least I believe her 2022 testimony that in fact he was stone cold innocent is suspect. If someone's innocent, and you have a witness, at least once you're charged, you ask them to come forward. It's inconceivable to me that Eddie Whiteside would not at least have asked her, "Rochelle, please come forward and tell the truth."
Is Eddie Whiteside's race in this record?
Is Eddie Whiteside what?
His race. Is it in
Eddie
the
Whiteside's race in the record? I don't know.
All right.
I don't know, Your Honor.
Okay. So he in 2001 is arrested by the police. Ms. Nice knows that.
Yes.
Okay. The court gave petitioner the opportunity to subpoena Mr. Whiteside. In fact, the court continued the hearing to give additional time for petitioner to secure his testimony at the hearing. Is that correct?
Yes, it is.
And in fact, Mr. Pat Harris told the court that you had subpoenaed Mr. Whiteside, correct?
I don't recall if Mr. Harris told the court that or not. I'm not disputing the court's recollection.
Okay.
I just don't recall.
The court's memory is that Mr. Pat Harris said we were able to subpoena Mr. Whiteside. He wasn't happy about it, but that the petitioner chose not to call Mr. Whiteside without knowing what Mr. Whiteside was going to say. So my point is that the petitioner had an opportunity to call Mr. Whiteside at this hearing, but failed to do so because you had him under subpoena.
Sure, I'll accept that for the moment because I
Okay.
can't recall. But let's be clear, Your Honor, the people had an opportunity to subpoena Mr. Whiteside too in the lead up to this. And since they do have a burden of rebutting the presumption of prejudice at some point, they had a motive to call Mr. Whiteside too and simply present his testimony. No, I never hit her. She's right when she testifies to that. So both parties had an opportunity to call Mr. Whiteside. The fact that petitioner elected not to call a witness who wouldn't speak with him is, as Your Honor knows from her own trial experience, not unusual. It may not be the standard, but it's certainly not unusual that you don't put a witness on the stand who hasn't spoken with you. The third point about the dispute between the contemporaneous documents and Ms. Nice's 2022 testimony is to look at the charges that were brought. Remember, Ms. Nice's version of the events is very simple. We argued, I came into the house, I gave the baby to Mom, I closed the door, and I hit him. Mr. Whiteside is charged with endangering the health of a baby, cruelty to a baby. There's no scenario under which, or that I can think of, under which Ms. Nice's 2022 version of events accounts for that charge. Police they don't just make up charges. They base it on the evidence from their investigation. So I don't believe her current version of what happened accounts for the fact that police charged the case the way they did. I just think they're irreconcilable. And the final point about which of these versions to credit deals with Ms. Nice's 2020 declaration, where she addresses the Eddie Whiteside incident. And I think it's paragraph 27 where she describes this incident with Eddie Whiteside. And she said, the reason I didn't report it or answer or reveal it on my questionnaire is because, and she uses this phrase, and I hope I'm getting it right, Your Honor, but it's close. She uses the phrase, I didn't view his conduct as criminal. I didn't view his conduct as criminal. Now, Your Honor's initial reaction, I can tell as well, it wasn't criminal. He just stood there. And that's true. That's an accurate way to describe what Mr. Whiteside did. But it's a pretty unusual way to describe it. I know Your Honor, in her experience as an advocate, probably drafted declarations. I've drafted declarations. My colleagues from the prosecution have drafted declarations. If the witness comes and tells you, you know what, here's what happened. I hit him. He didn't hit me. It's a pretty unusual way to phrase that in your declaration by saying, I didn't view his conduct as criminal. It's an understatement to say that's an understatement. There was nothing Eddie Whiteside did, according to the 2022 version, that's remotely criminal. Why would you express it by saying, I didn't view his conduct as criminal? You would say, he didn't do anything to me. He didn't hit me. I hit him.
But they were in an argument before they came into the house, yes?
They were arguing about her belief that he was cheating on her.
Correct. They were in a verbal altercation.
They were arguing, yes.
Okay. Could that be what she was referring to? The verbal altercation?
I don't believe so. I don't believe so when she says, I didn't view his conduct as criminal. That's why I didn't report it. It's hard for me to imagine whatever she expressed to counsel that led counsel to suggest that this is the language you should use, but it isn't. He never hit me, I hit him. That's a very unusual way of expressing that, Your Honor.
Okay.
Unless the court has other questions on the existence of misconduct, I'd like to turn and I think, of course, we've established by at least a preponderance of the evidence that there are false answers or evidence that was not revealed. And I think that's all we have to do for the initial predicate question of misconduct. The question then is whether the state has carried the burden of rebutting that presumption of prejudice. Now, I started my misconduct discussion with a point that we disagreed on, Mr. Harris and I. And we've been wrestling with this case for many years. So I'd like to start this section of the discussion with some points of agreement that Mr. Harris and I have. We agree that the most important question, it's not dispositive, but the most important question for the court in resolving whether the state has rebutted the presumption of correctness is whether the false answers were given intentionally or not. It's not dispositive. An unintentional false answer, as the Supreme Court has said many times, can result in relief, and an intentional non-disclosure sometimes can result in a denial of relief. But it is the most important factor the court has said a number of times. I think Mr. Harris and I, Mr. Dave Harris and I agree that Ms. Nice is the critical witness for resolving that inquiry. And the resolution of that inquiry involves a number of different steps, which I'd like to go through. One, it involves an assessment of her general credibility as a witness, the factors we would apply to any witness, whether it's
Slow down.
whether it's a...
I will keep reminding you.
Thank you, Your Honor, and I'm sorry to make you do that.
That's all right.
And Madam Court Reporter, I apologize to you as well. Again, let me just say I have a standing apology if I can do that.
Okay. So, and, we have, I've scheduled this for the entire day, not that it will take the entire day, so feel free to take your time to make all the points that you need.
I'd love to say, Your Honor, that was the reason I was rushing but it wasn't, but I will keep that in mind. So I think we talk about the general credibility factors that are relevant to any witness. We talk about what the state has called the Manriquez factors. Those are factors identified in Ray Manriquez, synthesized from a number of cases. And we talk about what Boyette, the Supreme Court decision in Boyette, called the surrounding circumstances. And we try to use all those to assess whether these answers are credible, whether these explanations are credible, whether it was intentional or not. So let me start with the general credibility discussion. Evidence Code 780, which is cited in the brief, lists the factors that fact finders should consider. It's been distilled into a number of different jury instructions, civil and criminal, and I'm sure the court is familiar with it, but just let me, in an excess of caution, I have a slide that conveys a couple of the more important factors for assessing credibility. And this is from Calcrim 226, Your Honor. Did the witness make a statement in the past that is consistent or inconsistent with his or her testimony? I'll skip to the bottom one. What is the witness's character for being untruthful? And then the middle one admonishes that we should evaluate the testimony in light of the entire record. So really what we're looking for, at least initially, is a search for consistency. The state points this out in its brief. She's suggesting she's been a consistent witness, and that's a reason to find her credible. So let's explore that for a moment. In 2000, Ms. Nice filled out that paperwork in connection with her restraining order. And here's what she said about whether she was in fear for her baby's life. This is what she said under oath in the paperwork in 2000. Michelle does not want Marcella to be able to come anywhere near her her child after it is born. Michelle feels Marcella would try to hurt the baby with all the hate and anger she has for Michelle. That was under oath in 2000. Here's what Ms. Nice said under oath in 2022 about whether she had fear for her baby. This is Mr. Pat Harris. Okay, did you have a genuine fear that she was going to hurt your child? Nope. You never were afraid of that. Nope. There is, I referred to a chasm before, there's a chasm between those two, both under oath, those two positions, Your Honor. One is there's a tremendous fear with all the anger and hate she has for Michelle, and the other is I wasn't in fear at all, never.
Okay, remind me, at the hearing, was this were the questions at the time after the child was born? Because Ms. Kinsey came, the incident arose when Ms. Nice was expecting the child.
Yes.
Okay, so the questions that you're citing to in the transcript, was that about after the child was born or when she was expecting the child?
It's actually, these questions are asking her to explain why she gave a different response in 2000. So they're specifically directed at this portion of the narrative.
Thank
It's
you.
pages 51 to 56 is where this entire discussion occurs. Here's what Ms. Nice said in 2020 about why Ms. Kinsey showed up at her house there's some dispute as to whether it was in the morning or in the evening. Both are in the record, but why she showed up in the house. Here's what Ms. Nice said in her 2020 declaration. My boyfriend, Eddie Whiteside, was the ex-boyfriend of Marcella Kinsey. She was not happy with the current arrangement and came to my apartment to confront me about it. That's paragraph 20 of the evidence of her declaration, which is evidentiary hearing exhibit 10. Here's what she said at the evidentiary hearing about why Ms. Kinsey came to the house that night or that morning. Paragraph 20, Mr. Pat Harris is asking her about this discussion this piece we just talked about. Paragraph 20, please, is that a truthful and accurate statement? Answer, more or less, yes. Question, more or less, which part of it is less? Answer, she, Kinsey, didn't come to confront me. Again, there's a chasm between these two. Kinsey came to confront her, or she didn't. They're both under oath. There's a stark inconsistency here, and in connection with what we look at, consistency, this is directly relevant to her credibility.
Okay, but we're looking at a statement. How many years between the two statements? When the statement was made is it 2001?
No, actually, the statement in the 2020 declaration was made in 2020. That's why I called it the 2020 declaration. And the testimony was 2 years later at the evidentiary hearing.
Okay.
So there's a 2-year gap. Here's what Ms. Nice said in that 2020 declaration as to whether she was the victim of a crime. I did not interpret the circumstances leading to the petition for a restraining order as a crime. I still do not. This is again 2020. This is paragraph 20, Exhibit 10 and paragraph 23. Here's what she said in her 2022 testimony. Question by Mr. Pat Harris. She kicked in the front door of your house. Is that correct? She did. Did you consider that to be a crime? Yeah, sure. Again, there's a stark inconsistency there. It's a crime or it's not.
And remind me again, the 2020 declaration was prepared by Mr. Zaki.
Yes.
And Ms. Nice's testimony was that because of COVID, she, you'll have to find it in the record. She either reviewed it over Zoom or reviewed it over the phone one time.
She didn't review it in person because of COVID.
Because of COVID.
She reviewed it electronically at some distance, whether it was by Zoom or over the phone with him.
All right, thank you.
And I'm sorry, I've already forgotten what I said.
I think you said by phone. By
Oh,
Zoom
by
or
phone,
by
okay, thank you. It's the true bathtub memory. And this last, what I'll call inconsistency, Your Honor, is a little more nuanced, but let me give a crack at explaining it. Because we now know that Ms. Nice testified twice about what happened to her on September of 2000, the basis for the restraining order. She's testified to it twice. She testified to it in December of 2000 in connection with the restraining order litigation, and she testified to it at 2022. And I would love to be able to put up a fancy PowerPoint slide, Your Honor, showing the December 2000 testimony and comparing it to the 2022 testimony, but I cannot because of the age of the restraining order litigation. We were unable to locate a transcript. But here's what we do know. So I don't know what she testified to in front of Judge Pfeiffer on December 13th, 2000 that compelled Judge Pfeiffer to grant that restraining order. But here's what I do know. I do know that under the law at the time, Judge Pfeiffer could not grant that restraining order unless she found, according to Civil Code section or Civil Procedure Code section 527, she had to find clear and convincing evidence of unlawful harassment. And I think I have that section up here. If the judge finds by clear and convincing evidence that unlawful harassment exists, an order shall issue prohibiting the harassment. And recall, this was a petition to prohibit harassment. So that's the standard that Judge Pfeiffer had to find in order to issue a restraining order. Unlawful harassment, what does that mean? I'm relatively new to this area of law. I deal mostly with homicides, Your Honor, so I had to look it up, and what I found was that in that section, harassment is unlawful violence, a credible threat of violence, or a knowing and unlawful course of conduct directed at a specific person that seriously alarms, annoys, or harasses the person. So this is what Judge Pfeiffer had to find when Ms. Nice took an oath, testified in December of 2000. She had to find by clear and convincing evidence that there was unlawful harassment. We don't know what she said, but we know that this is what was required by Judge Pfeiffer to find. And we know that Judge Pfeiffer did find it. She issued a restraining order, a 3-year restraining order, in favor of not only Ms. Nice, but in connection with the baby as well. And the last point we know is that in her 2022 testimony, Ms. Nice was trying to explain why it is that she was saying she had no fear for her baby, or what kind of fear did she have. And here's what she said in 2022. Question by Mr. Harris, why are you telling us today that you were not in fear of your baby's life? Answer, I said I was in fear if we fought. She wasn't going to deliberately hurt my child. But if we fought and rolled around like some dummies on the ground, then yes, I would be fearful of that. I would lose my child doing something stupid like that. Now, I don't believe, and the court may disagree with me on this, but I don't believe that if Ms. Nice had told Judge Pfeiffer that, if she had told Judge Pfeiffer, I don't believe she would deliberately hurt my child, but I'm afraid that we'll get into a fight and we'll roll around on the ground like dummies, that Judge Pfeiffer would have found clear and convincing evidence of unlawful harassment by Ms. Kinsey.
Well, we're going back on theoreticals because the restraining order requested 2 things. One, a restraining order protecting Ms. Nice, and also her unborn child. So there were 2 parties, that petitioners, if you will, that were asking for protection. And so the court could have issued a restraining order protecting Ms. Nice, I guess not the unborn child. She could have issued a shorter restraining order sometimes is the case, just to let, circumstances cool off. And where in the record is Ms. Kinsey's response? Do we have it?
We don't. We don't have a transcript of that here, but I think Your Honor made a really important point there, is that Judge Pfeiffer could have issued a shorter restraining order. Remember, the claim, Ms. Nice's claim was that we would roll around on the ground, and because I'm pregnant, I'm carrying the baby would be injured. You don't need a 3-year restraining order if that's the testimony in front of you, that you're worried that because you roll around while pregnant, the baby will get injured. You don't need a 3-year restraining order that covers both Ms. Nice and the baby. She extended that restraining order to 2.5 years after the baby was born. And that tells me that the predicate for that, the factual predicate for that, wasn't, Your Honor, I'm afraid we'll roll around on the ground like dummies and she'll hurt the baby in utero. Because that restraining order is 2.5 years after the baby is no longer in utero.
And was Ms. Kinsey, again, in the record, had she been charged criminally at that point? Do we know?
I don't know the
because
exact
she was charged criminally for the actions against Mr. Whiteside.
She was charged criminally, I believe, with vandalism, Your Honor, in connection with the 923 incident. But I'm not sure when. So
Okay.
I can't answer that specific question.
Okay. And so we don't know exactly what Judge Pfeiffer had in front of her at the time. In other words, was there other evidence of a restraining order, a criminal restraining order?
We don't.
Protecting the party. So and again, this is just, I mean, you've raised it, but I want to be clear in terms of what's in this record. We don't have what was in front of Judge Pfeiffer, either in terms of evidence or if Judge Pfeiffer ran a klutz check before the hearing, because the statute, and again, we'll need to go back, and I'm going to have the parties do this in post-trial briefing. The statutes for restraining orders, sometimes, and I'm not sure about the civil, but in family law cases, require that the court go through and do a klutz check. Is there another restraining order in the system involving the party? So we don't know if that was done in this case, if there was a restraining order that was part of what Judge Pfeiffer considered at the time, correct?
We don't.
Because there's an absence of information.
Correct, because of the timing. But let me just say this, that if in fact there is another order between these parties, then Ms. Nice was involved in yet another lawsuit. So I'm not sure this...
No, I'm talking about from the criminal proceeding involving Ms. Kinsey, because she was charged with vandalism for her conduct towards Mr. Whiteside, yes?
She was charged with vandalism. I don't know if it was in connection with the tires or the door.
Okay, thank you.
And I misunderstood the court's question. Yes, if there's a restraining order in connection with a criminal case, then that would obviously not suggest that Ms. Nice was involved in another lawsuit. I thought you meant another civil one. So those are, in fact, I think some important inconsistencies in Ms. Nice's versions of events, evolution of her versions of events from 2000 to 2020 to 2022, that suggests that she hasn't been as consistent as we would like in a witness that we're going to find credible. Which brings us to the Manriquez factors. These are the factors that the Supreme Court in re Manriquez synthesizes from a number of jury misconduct cases. They're not factors that the court announced for the first time in Manriquez. It's a synthesis of a long-time California law. And one of there's a number of factors, but one of them is, did the juror, in assessing whether the juror's testimony is credible and whether she gave false answers, he or she gave false answers intentionally or not, one of the things we look at is whether they cooperated with the search for truth in the post-trial context. Manriquez, of course, is a good example. So is, I think, San Nicolas. Manriquez was a case where the juror did not reveal that she had been abused as a child 40 or 50 years earlier. During jury selection, she didn't reveal it. But in a post-trial questionnaire filled out within days of trial, she revealed it. And then she spoke with both lawyers about it, both lawyers representing the defendant and the prosecution. She signed 2 declarations, and then she willingly testified. And the court, a number of times in the opinion, cooperated that a juror who is sincere when she says she genuinely forgot it and explained it, this is how that juror would react. This juror cooperated with both sides in the search for truth. Same thing with the juror, I think, in San Nicolas, who 2 months after trial, talking to defense counsel, brought up the fact that he had not revealed. And the court said if he was intentionally not revealing it, why would he affirmatively bring it up in a conversation with defense counsel? That's the type of cooperation that the Manriquez factor focuses on. So what do we have here? Well, we don't have that. We have a juror that admittedly spoke with a defense investigator before the habeas petition was filed.
2015.
2015.
So how many years after the trial?
10 years after the trial, Your Honor.
Okay.
So she
And
spoke with...
and she voluntarily spoke with
She
the
did.
investigator.
She did speak with the defense investigator. Defense investigator brought up this subject because she just had the documents, asked about it. Ms. Nice responded. When the petition was filed shortly thereafter, within months, things changed. Ms. Nice refused to speak with anyone from the defense. She refused to speak with anyone from the prosecution. She was subpoenaed to testify, as Your Honor knows. She exercised her privilege against self-incrimination, and she refused to testify unless she was given immunity from prosecution. This is as far from a cooperating witness, I think, as you can get. This is as far from, I can see from Your Honor's reaction that there's some tension here.
Well, I specifically want to ask you about the final instruction, and again, I'm going to ask the parties to find this in the record. 3590. It's a final instruction that any trial court judge gives in a criminal case. And I'm going to read you the second paragraph. Now that the case is over, you, meaning the juror, may choose whether or not to discuss the case in your deliberations with anyone. It doesn't say you must. It doesn't say you shall. It says you may. So how do you reconcile 3590, which is the final instruction of a trial judge, and I'm assuming was the final instruction in this case? How do you reconcile that with your argument now that, well, she didn't cooperate? I mean, she originally did in 2015, and then she decided she was going to get an attorney, and she did ask for immunity. She asserted her Fifth Amendment right. So I'm worried about staying in my lane. So we have an instruction, right? 3590. We have a time lapse between the cases that you cited to the court. It was relatively short after. In Manriquez, it was actually a post-trial questionnaire. The other case, it was within a couple of months. So we're talking about over a decade, one. Number two, we're talking about her invoking her Fifth Amendment right. And I don't know what case says that any court should consider that invocation in making a determination regarding the credibility, even Manriquez, but I'll have you answer that.
Sure, thank you.
Okay.
Thank you for the opportunity. I think Manriquez does stand for that proposition when it broadly says we're looking at whether the witness cooperated. But let me get directly to your question about the jury instruction. And this in some ways echoes my colleague Mr. Dave Harris's position here, which is she had every right to hire a lawyer as she did and exercise the Fifth, and that's true. And that instruction that you've cited, yes, that's a standard instruction given in every case. And I think the point of the California Supreme Court's decision in Manriquez and the decision to look at cooperation is that that instruction was given in Manriquez too, Your Honor. It's a standard instruction. It was given in Cowan. It was given in Boyette. It was given in San Nicolas, where they looked at the cooperation. The state is quite right when they say she had every right not to speak with the defense. She had every right to exercise her Fifth Amendment privilege. That's true, but so did the juror in Manriquez, so did the juror in San Nicolas, and they didn't. And that's why it's relevant, Your Honor. And that's why Manriquez says we look at cooperation. It's not that she didn't have the right to do this. She had every right to do it. But when you take that step, there's an inference that can be drawn, and Manriquez says we're permitted to draw that inference. So that's why I think I understand the instruction Your Honor is focusing on, but I think, in fact, it points in our favor because that instruction was given in those other cases as well. It's a standard instruction. The second Manriquez factor, Your Honor, is what I'll call the notice factor. Was the juror who intentionally or unintentionally gave a false answer, was he or she on notice of the relevance of the information? And let me just briefly reference a couple of cases that were relevant on this point. Diaz, a case from the 80s, and Manriquez. Manriquez, the juror said, what the juror didn't reveal was her abuse 40 years earlier as a child. And the reason it was important to Mr. Manriquez's case is that the penalty phase of his capital trial, he introduced abuse as a child. And what the court was careful to note was that there was nothing in the publicity in the case or the voir dire that would have alerted the juror CB and Manriquez, that in fact this was important. So that was a factor that suggested it wasn't intentional because she didn't know it was important when she didn't reveal it. Diaz stands in sharp contrast. Diaz was a case where what the juror didn't reveal was that several years earlier she had been, I think, raped at knife point or assaulted with intent to rape at knife point. And the court was clear to say, look, the voir dire made clear that this was a knife attack. And so that should have put you on notice and made you more inclined to think of this information and reveal it. So what do we have here? We have, as the state has properly conceded, I think, recognized that the state Supreme Court said the publicity in this case was not just nationwide, it was worldwide. And the parties at trial talked about the fact that there was more publicity here than the O.J. Simpson case. And while the details of the state's case may not have been in all that publicity, the general contours were. And the general contour was that Scott Peterson had assaulted his pregnant wife and killed both her and their unborn baby. That's what jurors were aware of when they came into voir dire. Ms. Nice admitted that she'd seen the general publicity. And so in terms of the notice requirement, Rodriguez, should a juror have been on notice that if in fact you feared for your baby's life because you thought you were being assaulted, I think the publicity put Juror Nice on notice that that was an important factor. And I think that Rodriguez factor weighs against the state's ability to rebut the presumption of prejudice.
Okay, so let me go back to the jury questionnaire, 97A.
I'm sorry, Your Honor, I don't have 97.
That's all right, I'll read it to you.
Oh, thanks.
The jurors that sit on this case will be instructed that they must base their decision entirely on the evidence produced in court, comma, not from any outside or pre-existing opinion or attitudes. Can you do that despite what you have read, heard, or seen about this case? She checked no.
She did.
Any follow-up on that from Mr. Garagos?
I don't recall. I assume the parties thought it was a mistake, but I don't know. It seems astonishing to me, Your Honor. It seems absolutely consistent with the idea that she had some kind of predetermined bias in the case, and she was talking about it there, but I don't believe there's any follow-up on it.
Well, but isn't that pretty important to follow up? I mean, the whole reason for these questionnaires is for the attorneys to look at answers carefully and follow up and say, you know, I noticed you've given all these answers right now, but I noticed on 97A you checked no. Ms. Nice, or juror number 7 at the time.
Yes.
Was that a mistake? Can you explain? Isn't that what attorneys are supposed to do?
I agree completely, Your Honor.
Okay. All right.
I was not there, Your Honor, but I agree completely with your assessment.
Okay.
Okay. So the third Rodriguez factor is to look directly at the answers, the explanation for the false answers. And we have a number of different answers that at least I suggest we've carried our burden of proving false, and we have a number of different explanations. And so I'd like to briefly go through those. Question 54 was the lawsuit question. There were 2 different lawsuits. And with respect to the restraining order, there was an explanation given. So Ms. Nice was asked, why didn't you reveal the restraining order on the juror questionnaire when you were asked if you were involved in any lawsuits? And she gave an answer, and she said, as Your Honor suggested earlier, we're back to that, she gave an answer that said, well, I didn't know that I thought a lawsuit had to involve money damages, and this didn't involve money, so I didn't think it was a lawsuit. And the state suggests that the state points out that Ms. Nice is not a lawyer, and therefore that's not an unreasonable determination. And once again, I agree with my colleague, Mr. Dave Harris. That is not an unreasonable explanation. And were it the only explanation in this case, we wouldn't be here. We would have been out of court a lot earlier, Your Honor. And that's why Cal Crim 226 and Evidence Code 780 are so important. We look at all the answers together. We don't just pick out one. Because I think the very next explanation is in substantial tension with that explanation. And the very next explanation deals with the civil damages lawsuit. Ms. Nice was asked, why didn't you put that on the questionnaire? And her answer was, well, there were no subsequent proceedings. I dismissed it. Okay, so if you didn't reveal the restraining order because you thought it didn't involve damages, the civil lawsuit did involve damages, so you should have revealed that. And if you didn't reveal the civil lawsuit because you dismissed it and there were no subsequent proceedings, you should have revealed the restraining order litigation because not only were there subsequent proceedings, you testified in December of 2000, but there were the subsequent violations that were directly related to it. So there's a tension. They're not irreconcilable, I know that, but there's a tension between them that if it doesn't raise a red flag, it raises a yellow flag. And that's why the CalPrim and Evidence Code 780 are important. We have to look at everything together. So let's look at some of the other explanations that were given. Can't just...
Doesn't CalPrim 226, I don't have it in front of me, but it talks about how people sometimes forget things, honestly forget things, or make mistakes about what they remember. And that's, that I agree with you. 226 is an important instruction, and every trial judge up and down the state reads that instruction when they tell the jurors this is how you're to look at the evidence. But people can honestly, forget things or make mistakes about what they remember, and it's up to the jurors to choose based on all the evidence whether or not they believe that the person honestly doesn't remember or that they were not being truthful. That's what the instruction says.
Yes, that's true, and that's the important point about looking at it all together.
Okay.
And so let's talk about some of the other explanations.
Okay.
I think there's a tension here. I can see it's not irreconcilable. She could have forgotten one and misremembered another, certainly. So let's look at some of the other explanations. Let's talk about her explanation as to why she didn't reveal what I'll call the door smashing and stalking incident from 923, the Kinsey incident. She offered actually a number of explanations for this, which to me in itself is a little curious. It was a landlord's door, my mom was living there, minor indignities. I have a slightly different definition of victimhood than many people, and I never testified at a criminal trial. The fact that there's a number of explanations offered and offered by the state to defend this, I think itself is concerning. But let's take them one at a time, Your Honor. I think at pages 16 to 17 of their reply brief, the state argues as follows. Petra, I think we have a slide. The door damage was to the landlord's door where her mother was residing. So let me break that down. The landlord's door where the money was residing, that's where her mother was residing. That's why it wasn't revealed. And that's why it's important to look at all these answers together. The state, I think, correctly notes that Ms. Nice is not a lawyer, and that's why her response to the lawsuit question, she says she didn't know that a lawsuit, she thought a lawsuit required damages, and so the restraining order didn't, and that's a perfectly reasonable explanation for a non-lawyer. Here the state's position is a bit different. Apparently, Ms. Nice, when she answers the questionnaire, is making a distinction between the landlord's ownership interest in the property and her interest, possessory interest, as a tenant for 9 years. Now, I don't believe that's reasonable for anyone to make. Perhaps a first-year law student excited about property law would. But I don't believe that's reasonable that anyone would make, much less a juror who the state has pointed out a number of times is not a lawyer. And so we can accept her explanation about the lawsuit. It's not reasonable that she would make this fine distinction between ownership interest and possessory interest.
So this is the respondent state's crafting of their argument in the brief. This is not Ms. Nice's testimony. Am I correct?
This is the crafting. I'm sorry, Your Honor.
No, go ahead.
This is indeed the way the state has crafted its defense. But to the state's credit, they did ask, was it the landlord's door? And she said yes. And they did ask, Ms. Nice testified the fact that she wasn't on the lease, her mother was on the lease. And that's really the next point I wanted to point out in terms of the testimony, is the suggestion that this was where her mom was residing. That's true, but it's not entirely true. Ms. Nice herself testified, I think, Petra, thank you. How long did you live at this house? Answer, for years. I don't know how many. Question, approximately 9 years, does that sound right? Answer, sure. So Ms. Nice was living there with her mother for 9 years. The suggestion that she would have thought when answering this questionnaire that it was a landlord's door, I don't have to worry about this, is, I think, unreasonable, especially someone who the state points out is not a lawyer.
Okay, would we agree when you look at the questionnaire as a whole, and now that Ms. Nice has testified, that she is a person with a limited educational background? Agreed?
I suppose so, Your Honor.
Okay, and Mr. Pat Harris raised questions during her testimony about the fact that she didn't know where her mother or her father were born. Do you remember that?
I do remember that.
How is that relevant in this case? If at all?
I'm puzzled to see the connection. I'm desperately trying to find one because I know Your Honor must think it's relevant. But I don't see the relevance, at least off the cuff, Your Honor.
Okay.
The fact that she didn't know, or she said she didn't know where her parents were born. I suspect, from my assessment of Ms. Nice's testimony, she was a feisty witness, and good for her. I suspect that the question marks as to where your parents were born were more in the sense of, it's none of your business, than I genuinely don't know where my parents were born.
Well, there wasn't follow-up on that either, right?
Correct. And I think there was no follow-up on that, as opposed to, I think, 97 that you asked me about, because
Right.
it probably wasn't central to the case as to where your parents were born.
Okay, but it was,
So-
but I guess my point is, but it was brought up in this evidentiary hearing. I believe I sustained an objection after a couple of follow-up questions. But, just looking at the questionnaire generally, again, going back to her responses, and you start with the questionnaire, they have to have a purpose, and the purpose is to kind of give some indication to the attorneys about the educational background, the life experiences of the juror, and the court notes that there were several inconsistencies in this questionnaire, right?
Yes, Your Honor.
Okay, and for example, she talks about, there was a question about educational background, and had she ever had training, just a moment. So questions 27 and 28. What's your highest level of education? Some college or tech school. Please list all degrees. She says medical assistant, CNA. The next question. Have you ever studied or received training in medicine, psychology, psychiatry, social work, sociology, or counseling? She says no. That's the very next question, or in the question before, she said she had training as a medical assistant in CNA. So I guess, looking at the questionnaire as a whole, there were inconsistencies known to Mr. Garagos and Mr. Pat Harris at the time they were conducting their questioning of Juror 7. Agreed?
Yes.
Okay. So getting back to your door smashing incident, your position is that this explanation about the landlord's door is too nuanced for the court to really find credible.
I believe it's too nuanced for the court to find credible for someone who's not a lawyer, for a lay person. Most people who have lived in a place for 9 years, if someone's screaming outside their house, I mean, let's be candid. Ms. Kinsey didn't come and scream for the landlord to come out of the house. She didn't kick in the door to meet the landlord. She didn't track the landlord down and call and hang up, and she didn't suggest to the landlord that we need to settle this on the street. This was between Marcella Kinsey and Ms. Nice. The landlord really didn't feature into any of Ms. Kinsey's actions, Your Honor.
Okay.
So let me move to the second one of these, the broader explanations, the minor indignity explanation that Ms. Nice put in her declaration and testified a little bit about at the hearing. These were just, she has a slightly different understanding or impression of what it means to be a victim, and this didn't rise to that standard. Let me talk a little bit, we've talked about the facts of the 923 incident, but when someone comes to your house screaming for you to come out so they can fight you, slashes your boyfriend's tires, kicks in your door, follows you to your new place, calls you, hangs up, says we're going to settle it on the streets, and then follows you in a car one day to work, by anybody's standard, I don't think that's a minor indignity. I don't think it's reasonable to say that's a minor indignity. And perhaps more importantly, since I suspect this is the question on Your Honor's lips, I don't believe it meets the minor indignity standard that Ms. Nice herself gave the court. Here's what Ms. Nice described as a minor indignity. Minor indignities, shoving matches, raising of voices, and other undignified means of communicating frustration do not stick out to me, let alone cause me to feel victimized the way the law might define that term. And let me just say, this is perhaps the even more rare moment where I agree with Ms. Nice. This is a pretty good definition of a minor indignity.
Well,
Shoving matches.
Shoving matches could be it can be a battery, a criminal battery.
Well, I view shoving matches as something, I'm not going to do this to Ms. Vasquez.
I know, but an unpermitted touching constitutes, I don't have the instruction in front of me, but
Yes.
under the penal code, you know probably better than I do, constitutes unpermitted touching of another individual is a criminal battery.
It is a
Okay.
criminal battery. But putting aside what level we can say shoving matches really conveys, whether it conveys a serious shoving match or simply a bump, raising of voices, other undignified means of communicating frustration, that would certainly, I think we would agree, that is a minor indignity. But that is not what happened on the evening of 9/23. This wasn't the raising of voices and undignified means of communicating frustration. This was slashing tires, kicking in a door, getting her new address, calling her, hanging up, telling her she's going to settle it on the streets, and then following her in a van, suggesting she was stalked. I don't believe, even under Ms. Nice's definition, that would qualify as a minor indignity, but it certainly doesn't qualify as a minor indignity under any objective sense of the term.
So when did the, and again, Mr. David Harris, you can address this when the people address the court, but the timeline. According to Ms. Nice, she and Ms. Kinsey sort of made up. Bygones be bygones. Yes?
I understand the testimony.
No, she didn't use the term bygones be bygones.
No.
But the evidence, the record evidence is that at some point, Ms. Nice and Ms. Kinsey made up about this dispute over Mr. Whiteside. Agreed?
Let me qualify my agreement, Your Honor. Yes, there is testimony where Ms. Nice says, at some point we were standing outside court and we said, all this over Eddie Whiteside, I'm paraphrasing also,
Okay,
and
yes.
I'm paraphrasing too quickly. All this about Eddie Whiteside, let's essentially let bygones be bygones. There is that testimony, but there's also testimony that after that, she called in a restraining order violation. So, and I think she said, well, I wasn't so sure that we were in agreement on this. That's my recollection of the timing.
Yeah, it would be helpful, Mr. David Harris and counsel, since we're going to have just a supplemental post-trial briefing. And one of the reasons I'm doing that, just so both parties know, is to give you an opportunity to have a last kind of word, if you will, to the court about these questions, because I realize that I'm asking questions that may be new and were not included in your briefing. So I feel the case is important and you should have that opportunity. But yeah, so the court's memory was the same as yours, that it was like, why are we doing this, Mr. Whiteside, this is ridiculous. But the court's memory is also that she was maybe in the hospital and had delivered a second baby with Mr. Whiteside, and she saw on a video that Ms. Kinsey was at a party holding the first child that she had with Mr. Whiteside, and that's what got her upset. That is the court's memory. Again, we're going to have to go back and look. That's why she got upset.
My memory is consistent with Your Honor, is that after the bygones be bygones semi-makeup, that there was a period she was in the hospital, she saw what she saw on video, and she called in the restraining order violation.
Okay.
The final explanation for why she didn't view herself as a victim is her testimony that, or her position, I think it's taken in her declaration, that she never testified at a criminal proceeding, and therefore she's not a victim. You know, it's difficult for me to articulate how strongly I feel about this one. If Your Honor's car gets stolen and no one is ever prosecuted, is Your Honor a victim of a car theft? Of course she is. If I walk out of court today and I'm robbed of $500 in cash and no one is ever caught and prosecuted, am I the victim of robbery? Of course I'm the victim of robbery. The idea that you're not a victim if there's no criminal proceeding is, to me, fundamentally unreasonable and not something Your Honor can credit as a legitimate explanation. It's just so far beyond the bounds of rationality, I think.
But the court's left the facts of this case. And the facts of this case are, you have an ex-girlfriend, you have the current significant other, I'm not sure the appropriate phrase to use, but Ms. Nice was living with Mr. Whiteside. His ex-girlfriend comes to the house. I mean, I think you appropriately said that Ms. Nice on the stand was feisty, and I think we all agree. She has, her life experience is very different from your experience and perhaps my experience. Agreed?
Agreed, Your Honor.
Okay. And so, in the context, I agree with you. I know if my car is stolen, I'm a victim of a crime. I know if someone, takes my purse or my cell phone, I'm a victim of a crime. But the lens through which you and I look at things is different from the facts of this case, because these people knew one another, there was a history, they made up, Ms. Kinsey, and so I think it's more complicated. I understand what you're saying, but I think it's a little more complicated given the facts of this case, because it wasn't a stranger who came to kick the door. It was someone that was known to both of the parties. So I understand what you're saying, but I think it's a little more nuanced, I guess.
I agree with the fact that it's more nuanced, but I'm not sure it cuts the way Your Honor's question suggests. If I, for example, if I know my best friend steals my car and drives it off and he's never prosecuted, I still know I'm the victim of car theft. The fact that it's a friend may make it worse, not better, it seems to me.
Okay.
I just think, regardless of the nuance Your Honor points out about the perhaps different backgrounds of Ms. Nice as a witness and me, and as you said, perhaps you, I still think the suggestion that you can't be a victim unless you actually testify is so far beyond the pale that it's not a credible explanation.
Okay.
And that brings us really to the Boyette, the surrounding circumstances, what Boyette calls. And I think there's a number of them here that are relevant in assessing whether the state has carried its burden of proving misconduct harmless. The first is the fact that when you look at the jury voir dire, and you look at the jury questionnaire, and you look at the contemporaneous financial records that Ms. Nice filed in support of her request for child support, is that this trial was going to impose a financial burden on her. We may characterize the depth of that burden differently, but the numbers speak volumes. She had $3,800 in expenses every month, $1,800 of income, $400 of child support, and I think she had $160 in the bank. So every month was going to get her deeper and deeper into a hole. We also know that the judge said 3 times when she was present, if you have a hardship, if you're not going to be paid for jury service, tell me, and you're you're going to get a hardship discharge. And 3 times she did not, and said she went to voir dire and became seated on the jury. So she was, for whatever reason, eager to get on the jury. We can talk about the contrasting implications. Some of those, she wanted to do her civil duty and sit on the jury. That's certainly one interpretation. Another interpretation is that she was harboring some kind of bias based on her own personal experience and wanted to get on the jury. Those are 2 legitimate explanations. During the jury trial, she gave Connor a nickname. She called him Little Man. She took the extraordinary step after conviction and after having put Mr. Peterson on death row of beginning correspondence with him, a series of letters. And the court has seen the letters. And the letters, each of them has various focus, but one of the focuses of every letter is Little Man, is Connor. And that too suggests a focus on exactly what we were concerned about with the failure to reveal that in fact when she was pregnant she had been assaulted and she was in fear for her baby's life. And the final surrounding circumstance, I think, Your Honor, is that when she was seated as a juror, Your Honor will recall she was an alternate.
Yes.
When she was seated as a juror, the court has the standard admonition. Your Honor talked about standard admonitions, and here's another one the court gave. When you're seated as a juror and you begin deliberations, don't take a firm position early. Don't announce it. Discuss the case. And she ignored that admonition, as I think we all agree. Now, that isn't misconduct. It's not a mandatory admonition. But what she did say before she even sat down at the table, when she was admitted to that jury room, according to Juror Atlas, she said, let's get Mr. Peterson for what he did to Little Man. That's not a quote, Your Honor. May I paraphrase it? But
I think you did paraphrase it, yes.
She didn't say, let's get Mr. Peterson for what he did to Laci. She didn't say, let's get Mr. Peterson for what he did to Laci and Little Man. She said, let's get Mr. Peterson for what he did to Little Man. That, too, is consistent with someone who has a focus on or a history of having been in fear for her unborn baby's life. So, Your Honor, I'll just conclude on this. Your Honor made a point before to say Ms. Nice may have had a different background, and so there may be a more nuanced understanding of her statement that she wasn't the victim because she never testified. And that's true. It's also true that the state has provided explanations for almost every one of the false answers. And I'm reminded, as I have often seen, and Your Honor may have seen this experience as well, I'm reminded about the prosecutor's argument they often make, the chicken soup argument, where they're talking about what defense lawyers have tried to do, and they say, look, the defense lawyer pulls out the carrots and says, this isn't chicken soup. Defense counsel pulls out the celery and says, this isn't chicken soup. And defense counsel pulls out the chicken and says, this isn't chicken soup. And the prosecutors remind the jury, you look at it together. You put all those things together and you have chicken soup. I think there may be rational...
I've never heard that argument.
Really?
So thank you.
Well, did I do it well, Your Honor?
In my many years, I have heard that argument. But thank you.
Okay. Well, I've seen it many times.
Okay.
I've seen it many times, Your Honor. And it makes sense. The point is, don't pick out things, give an explanation with this and move on. Look at things together. And I think when you look at things together here, you have the inconsistency about whether she feared for her baby's life, the inconsistency about whether she was a victim, the inconsistency about why Miss Kinsey came to the house, the non-cooperative witness. There's, again, explanations Your Honor talked about. There's explanations for every one of these things. You have the non-cooperative witness. You have the notice that she had by virtue of the publicity. You have some of the answers she gave. It was the landlord's door. It was my mother's house. I'm sorry, no, it's my apologies. You have some of the answers she gave to the questions. Why didn't you reveal the 923 incident? Well, it was the landlord's door, or it was Eddie Whiteside's tires. Any one of these explanations may be sufficient. But when you put it all together, Your Honor, I think it's chicken soup. I think we've not only carried our burden of proving misconduct, but I believe the state will be unable to carry its heavy burden of rebutting that presumption.
Okay, so let's go back to Mr. Baratlas.
I'm sorry, Mr.
Baratlas?
Baratlas, yes.
Okay. His testimony was she came in, and everyone agrees the first thing she said was something about getting him for a little man. Mr. Baratlas went on to say, we have a process. You need to sit down, we have a process. And there is no record evidence that she didn't follow that process, that they continued to deliberate, and that she engaged in the deliberations. Would you agree?
There's no evidence either way of what happened thereafter. I would agree on that.
Well, Mr. Baratlas was on the stand and could have been asked.
Indeed, he could have been asked by both parties, I suppose, within the confines of Evidence Code Section 1150.
Okay. The court's memory is, and Mr. Pat Harris is...
Sorry, Your Honor, you can't be asked about jury deliberations.
Oh,
You cannot be asked about that.
No, but whether or not she continued to engage, and the court's memory is that you're correct, Mr. Pat Harris, but whether or not she engaged in the deliberations, not the deliberations, but did she engage or refuse to engage, that's not in the record, right?
My recollection of Mr. Baratlas' testimony is similar to your own, Your Honor. Neither party, and within the confines of Section 1150, which I think is what Mr. Pat Harris was referring to, beyond that, I don't think either party asked Mr. Baratlas the question you just suggested.
All right.
And so one of the important things about the burden of proof, Your Honor, is that when there's a failure of proof, that falls against the party that has the burden.
All right.
Unless the court has other questions about the existence of misconduct or the presumption of prejudice, and pending any rebuttal Your Honor is kind enough to provide, I'm happy to submit the matter.
All right, thank you. I don't have any further questions. Thank you. But I am going to ask Madam Court Reporter, do you want to, we've been going since 10, can we go until noon and then take a break, or do you need a break? We can go. All right, thank you. All right, Mr. David Harris.
Just to kind of go into this a little bit backwards, it's not where I was going to start with, but since the court had raised this particular issue, the court will find at page, Reporter's Transcript 352, Ms. Baratlas testified that actually Ms. Nice had come into the jury room. She was seated at the table with the other jurors when she blurted out in a forthright manner, making no gesture or gesticulation, nothing aggressive in any way, and she made that particular statement. The record further establishes between pages 364 and 367, Mr. Baratla said that after Ms. Nice had made that statement, she deliberated with the jury following the process that they had started. Further, Mr. Baratla advised that there was a second juror that was replaced, another alternate was substituted, and they in fact did exactly as instructed by the judge, where they were to start all over again, and the question was asked, did the bailiffs come in to take the stuff down on the wall, and you had to start all over again with the process, and Mr. Baratla said yes. So what we want to point out for that particular area is the People versus Bradford case, which specifically says that's not misconduct. Even if she were to come in and have said that statement, it's not misconduct because an emphatic statement by certain jurors early in their deliberations does not disclose any improper conduct on their part, and that's Bradford. There's another case, the People versus Allen and Johnson case, and what that particular case said is what we can and do require is that each juror maintain an open mind, consider all the evidence, and subject any preliminary opinion to rational and collegial scrutiny before coming to a final determination. That's what Juror Baratla testified happened in this particular case. And not only did he testify that they did that, the court will note from the record in this particular case that they reached a lesser as to Connor when it came to the second-degree murder. So that's just not only, so there is no speculation as the petitioner is pointing out here. There's actual proof that she went back there, she did what she was instructed by the judge to do, and she reached a verdict. And in fact, Allen and Johnson go so far to state the Attorney General has cited no case, and we've found none, in which a juror was discharged for prejudgment based solely on comments made during deliberations. So the law doesn't even allow for the argument that really the petitioner is making in this particular case is that she said, oh, something should happen to little man, or because of little man. That's not what the law allows. And really what's happening at that point in time is the argument that's being made by petitioner is that they're conceding we have to prove bias. So which takes us way back to the beginning of the argument where it was originally going to start with. In this particular case, counsel, Mr. Gardner, was correct that there is a standard. We had talked about the standards in all of our briefing. Get my notes back in place here, but I just want to set the scene before we get to that particular point. As the court pointed out about Ms. Nice, we're going back to 2004. Ms. Nice is a single mom of several children who gets a jury summons in the mail. And she testified she put it up on her refrigerator. How did she know that that particular piece of paper was going to change her life, in which it has in this particular case? She'd never been on a jury before, as the court was pointing out, or counsel was pointing out, and she thought it would be part of her civic duty. Again, that's in Exhibit 5, page 4627. She showed up in court, and the process that she was originally given was she's handed this 23-page questionnaire. This 23-page questionnaire consists of over 116 questions. Almost all of those questions have multiple parts, so this is a very long questionnaire. And she testified when she filled it out, this is again her testimony here, she did the best that she could. So what we have here is a circumstance is the testimony before this court as part of this evidentiary hearing is the person who filled out the questionnaire who made lots of mistakes. There's no doubt about that. The court's already pointed out several mistakes on there where she's inconsistent on her answers. But being wrong does not necessarily make it false or make her a liar. It just might be that she's really bad at filling out forms, and that's something we're going to talk about as we go through this. When she was brought back to court, one of the things that I really want to point out is the defense, the petitioner said all along from the beginning, Ms. Nice had this secretive motive to get on this particular case. And finances was the way that she was going to do this. She was going to, in a sense, lie to the court about her ability to sit on this jury. But the court remembers her testimony when she pointed over here to the jury box and said, I walked in, the judge asked me the question, are you going to get paid? She said, no, I get paid 2 weeks. He says, you're excused. She gets up and she starts to walk 2 to 3 steps chairs down the row, and she's stopped by Mr. Garrigus, who's trying to get the court to keep her in the mix. And the circumstances at that point in time is corroborated because it's in the transcript. The judge goes, if you're willing to be here, sit down. So she's not making this up. It's in the transcript that this is what happened. She's trying to leave. This is not, wait, I really want to be here because I'm going to secretly get this guy. You know, if that's the case, she's the world's worst spy because she's already been excused. But instead, she's brought back and she's starting to ask questions about being fair. So the court did point out that Mr. Garrigus and the people had the opportunity to ask questions of her, and some of those questions were asked. For example, Exhibit 5, page 4622, which was her voir dire transcript from the jury trial. And
Sorry, 46 what?
4622,
Okay.
Exhibit 5, starting at line 1.
Just let me get there just a moment. I'm not sure if you have a PowerPoint presentation, but if you don't, give me a moment to get there. All right, I'm at 4622. What line?
Starting at line 1.
All right.
Towards the end of that line, she's asked, and do you consider yourself to be a fair person? Making sure the court's still with me.
I'm there. I guess the question that you're talking about starts on 4621, but I'm being too particular. But you're referring to the last sentence, which is, and do you consider yourself to be fair?
Correct.
Fair person. Okay.
And so her answer is, yeah, I try to be. And again, this is Miss Nice from back in 2004 to what the court saw here during the evidentiary hearing. Can you explain to me why you believe yourself to be a fair person? Answer. Because I know what it's like to be judged, and I know what it's like to be prejudged before somebody actually, you know, how many times have you walked in a room and someone has automatically pinned you for a certain type of person, and that's completely opposite of how you are, so question, okay, answer, I try. That's Miss Nice telling us way back then. This is the kind of person she is, and she's going to attempt to be fair in this particular case. I'm going to go through a list of things because counsel's saying you have to look at the totality of the circumstances. Well, Miss Nice testified during her voir dire in the hearing here. She hoped she could be a fair juror for the petitioner. That's part of Exhibit 5. She had no opinion based on pretrial publicity, was open to the possibility that he was falsely accused, had no fear of finding the defendant not guilty, responded to the questionnaire candidly, truthfully, and to the best of her ability. Confirmed that at no time during the jury selection process did any court case in which she was involved cross her mind, nor did she think about them when filling out her questionnaire. She did not intentionally omit any incident with Ms. Kinsey, since they didn't come to mind. The incident with Eddie Whiteside never crossed her mind. She did not form any conclusions regarding the evidence in the case until she was called into the jury deliberation room, and she recalled discussing the evidence with the remaining jurors before a unanimous verdict was reached. She had an abiding conviction that the charges were true on the evidence that was presented at trial, and her abiding conviction was solely based on the strength of the evidence presented at trial. She had no bias against Scott Peterson. When she was selected as a juror, she listened to all the evidence and decided the case based solely on the evidence in the courtroom and not some preconceived notion. That's the facts that have been presented to the court. Those are the undisputed claims or statements of Miss Nice about her involvement in this particular process. So what do we have from the defense? What do we have from the petitioner in this particular case? They start with their claim 1, which is that she was out to get them and she didn't indicate that she was involved in a lawsuit. So the standards, we start with Manriquez, as counsel indicated. The habeas petitioner bears the initial burden of showing that a juror did not disclose requested material information. Material being an important part. More importantly, though, an intentional concealment is strong proof of prejudice, while showing that a non-disclosure was unintentional may rebut the presumption of prejudice. Whether any disclosure was intentional or not is not dispositive. And then the court goes on, the ultimate question is for whether there exists, the juror was a substantial likelihood that they were actually prejudiced or biased against the petitioner. So in this particular case, starting with that particular framework, even though counsel says if there is a false statement, the burden shifts. That's not exactly what Manriquez says. Manriquez actually is saying you may even rebut the presumption if it's unintentional. So it's a little ambiguous as to that particular point. Then
So
there's...
let me go back to Exhibit 1. And in the caption page, and Ms. Nice said this was her handwriting, it doesn't use petitioner and respondent. The form says plaintiff, and she filled in Rochelle Neese, and defendant, Marcella Kinsey. You'd agree that terms plaintiff and defendant can be inferred as parties to a lawsuit, yes?
There's a potential that you can infer that, but I would point the court to page 7 down at the bottom.
Okay, just a
We
moment.
start... So at the very bottom, there's something that appears to be typed in.
You know, these are not Bates numbered. Page, let's see, just a moment. There's a handwritten number. I have 9.
What I'm going to point out to the court at the bottom, it's, I believe it's in the lower right-hand corner of that particular exhibit. It's typed in, it says civil.
Okay.
So this is a petition for an injunction, looking at the caption of the paperwork. A petition for injunction prohibiting harassment. This doesn't say lawsuit, it doesn't say crime, it doesn't say anything that might lead an ordinary person to say, I think this is a lawsuit. We pointed out in our briefing, and I'm just going to highlight this again because as the court indicated, U.S. Supreme Court has indicated, we're bringing in lay people off of the street, and all of a sudden we're asking them to understand the legal terms that we use that we take for granted. How many times have we heard jurors sit in the box and say, my house was robbed? A house can't be robbed legally. So they're wrong. But they're telling you what they believe is the circumstances in that particular case. It was a burglary, it was not a robbery. So they're wrong about what the crime is, but that does not make them a liar. So the fact that Ms. Nice in this particular case does not think that a civil petition for an injunction prohibiting harassment is a lawsuit doesn't make her wrong. Maybe legally, if this court wants to say, I believe this is a lawsuit, then by law, by definition, she would be wrong, but is that unreasonable?
Well, how do you respond to Mr. Gardner's position that then there is, I know the people's position is there's no document in front of the court that establishes that Ms. Nice filed a second lawsuit for damages, but her testimony is that she filed something, a lawsuit, I believe, was the term that she used for, she wanted money from Ms. Kinsey. So how do you reconcile that?
So how we reconcile that is when she's asked about that, going to reporter transcript, page 42 through 43, starting at line 18. She was asked, was this about some civil suit for a loss for money? And her response was, I guess. It was with Marcella. She did say she went to court, but that's where she said she dismissed it. It was over with, and her and I came to the realization that we were both being stupid, and this was over a stupid guy, and there was no need to continue. And that's at reporter transcript 94 through 95. So what we have here is an equivocal statement on her part that there may have been a second suit. That could have been because it's the burden is on the petitioner to prove that there was a lawsuit. Because if they prove there's a lawsuit, then they prove that her answer is false. So this is the initial pleading and proof stage. They must prove that there was a lawsuit. We never heard from Ms. Kinsey. We never heard from the custodian of records for the court that shows that there was ever a case that was filed. Now they're limiting it to saying, well, we didn't show any paperwork. That's true. They had on their witness list the custodian of records. The custodian of records could have come in and said we had a filing, or they could have said that there was no filing. But we know from the other exhibit, the temporary restraining order for the civil harassment, there was paperwork from that same time period that existed. There's not a transcript, not everything is there, but there's at least minute orders. So if there was something that was filed, it should be in the record. They had the witness that could have presented it on their witness list, and they never called it.
All right, but we do also have a jury instruction that says that the testimony of one witness can prove a fact.
That is correct.
Okay.
But our position is, we pointed out to the court in our briefings, Ms. Nice showed sometimes that she could be a little bit confused about things. And you saw that with some of her answers when she just started to say, sure. And when she would then be given the appropriate circumstances or shown a document, she then could explain it. And I'll talk about that a little bit later with some of the slides that were up on the screen. I also want to point something out. Counsel has indicated, and this is a subtle distinction, but the court will remember this, that exhibit number 1 was admitted, the letters were admitted, and I want to remind the court, we objected, and they actually were admitted for a limited purpose. So those particular items are not actually in for the truth of the matter. They were in for purposes of impeachment against Ms. Nice.
Well, and also, I believe, state of mind. So the letters were admitted, but not for the truth, but for state of mind of Ms. Nice, correct?
Correct. So
Okay.
then again, not for the truth of the matter. So when they were referring to the letters about what they claimed to be there, it has to be directly connected to Ms. Nice's state of mind. Otherwise, there's no connection. There's no admissibility for those particular items. We suggest to the court there's been no showing of those particular items. So going back to the lawsuit, and I just want to go through these step by step.
Okay.
So the lawsuit is the first question. That's 54. If the court finds that Ms. Nice was reasonable in her interpretation that this civil restraining order was not a lawsuit, or she didn't believe it to be, that's the end of the discussion on that particular case. Now, counsel is saying the fact that she's inconsistent about dismissing a case, so therefore she should have remembered the other case. That's not how somebody's mind works. And in fact, I'll remind the court, Pat Harris attempted to try to get Ms. Nice to remember coming in on the civil harassment order and testifying. And she was asked about that even after being shown page 4 of Exhibit 1, and this is Reporter's Transcript 42, she did not remember that she came to court and testified on the restraining order. And we know that she testified because there's a minute order. So again, there's no testimony of that, but there is a minute order from that court file that shows that she was there. And that helps the court address another question that was not really answered by the petitioner about what did that judge have in front of him. That minute order also tells us that Ms. Kinsey testified. So that judge had the testimony of both the petitioner and the defendant in that particular case. And it's a total job of speculation to try and figure out what it was that was said, and that would be completely inappropriate. But they're asking you to say, we want you to think bad about Ms. Nice because, that's Ms. Nice. Again, speculation doesn't work that way. And we pointed out also in our briefing, the evidence code section, that it's their burden producing the evidence, and if there's other evidence that they could produce, they could have produced Ms. Kinsey. That would have resolved this particular issue. And this is their initial burden of proving the lawsuit, so it was not our burden to produce Ms. Kinsey to say whether there was or wasn't a lawsuit. That was on them. So, evidence code section 412, as we cited, just read it real quick. If weaker and less satisfactory evidence is offered, when it is within the power of the party to produce stronger and more satisfactory evidence, the evidence offered should be viewed with distrust. The failure to call a logical witness is a failure of proof on the petitioner's part. And you'll see this repeated throughout these different things. We didn't hear from Mr. Whiteside. We didn't hear from one of the jurors that talked about money. So their burden, their responsibility to produce the evidence. So just to put this out there, the first restraining order, the people do not submit that was a lawsuit. In fact, the people would say, to a civilian that that was probably not. She didn't think that that was a lawsuit that was entirely reasonable. As to the lawsuit for money, yes, Ms. Nice was very equivocal about that, but she didn't recall the event of coming to court and testifying, showing that she's just not clear about that time period.
But you recall coming to court.
Well, she recalled coming to court filing the paper. She didn't recall the court coming back when she testified at the hearing as depicted in the minute order that was being shown to her. So the fact that a significant event, or what should have been a significant event of her going to court and having this hearing, she doesn't remember, when she's asked about this all these years later, it just again shows the point that the people have been making. With Ms. Nice, you got what you got. She's a very straightforward, sincere witness. She's telling you, very much telling you what's on her mind and what she thinks about things. That she called it the way she saw it. We may not like that. As the court said, we may not have the same lens that she has. I think that's kind of an understatement, but that's Ms. Nice, and that's her telling it from her point of view. So the fact that she didn't remember the circumstances of even the one that she admits she was involved with, when it comes to the lawsuit for money, the people's position is that really was part of the restraining order. She was shown paperwork from the restraining order and asked about these finances. She didn't recall, said it wasn't her handwriting, but she was asked about that. It's the people's position, they were part of the same thing. And our speculation is just as good as the petitioner's speculation when it comes to there being a second lawsuit. So,
Well, but she used the term, I dismissed it.
correct.
And it suggests, if you will, a reasonable interpretation. If you're dismissing something, that means you filed something because you're going to court and you dismiss it. But so that's another reasonable interpretation. Agree?
Yes, but
Okay.
if there are two reasonable interpretations, there is that instruction that would be used in a criminal case. The one that court indicates towards innocence in the criminal case would be the one the court would have to follow. Here we are in a habeas proceeding where the law says everything in favor of the conviction is the way that it should be applied. So if we were to take kind of bootstrapping those approaches here, we would find that we have to go with the one that just Ms. Nice was mistaken. But regardless, she was sincere in her testimony saying that neither, whether it was one or two, she never thought about them. They never crossed her mind when she was filling out the questionnaire because these things were behind her. She had dropped the matter or dismissed it according to her statement. As I read the statement earlier, she and Miss Kinsey had figured out this was over a dumb guy and she had put it behind her.
Well, but not so much behind her that she said she called about Miss Kinsey holding the baby in the video. So how should the court reconcile that?
The circumstances in that particular case are, as she was describing it, she was shown a video where she saw Miss Kinsey holding her son. And she believed that she called a family friend who just happened to be a detective, I believe is what her testimony was. We asked Ms. Bracksher about that, which is another witness we'll get to in a few minutes, but with Ms. Bracksher couldn't tell us what the entry on the screen was, that basically there was nothing that occurred, nothing, I don't recall what the specific wording was, and she said, I don't know what that means, you'd have to pretty much ask the officer. That's up to the officers to put those things in there. So once again, that's something that the defense, knowing who those officers were because they communicated with Ms. Bracksher, got the information who the officers were, could have called those particular people. They could have called Mr. Whiteside. They chose not to. And as the court indicated, he was a subpoenaed witness, and they were attempting to get in his statements through their investigator. So this was not somebody that was a surprise, somebody they didn't know about. This was just somebody they didn't want to take the risk of putting him on the stand, as counsel indicated. That, unfortunately, pursuant to 412, that doesn't work that way. You can't then, when you have that evidence available to you, you can't then turn around and say, well, it's not our problem. Well, it is their problem. The presumption is that what they offered should be viewed with distrust.
All right, so we are up at the noon hour. We're going to resume at 1:30. Thank you. I'm not putting you on a clock, but about another hour.
Hopefully. It
All
depends
right.
on the amount of questions from the court.
All right, and then, Mr. Gardner, do you want to have 20 minutes to respond? Or you don't have to.
20 minutes would be great. I think, sure I can do it in less.
All right, thank you.
Thank you, Your Honor. Have a nice lunch, guys.
Thank you. Victoria, I need you to help me find the case. Didn't find it in my notes. It's the case where we cited it in one of the last two briefs, so we just need to pull that up. It's where I'm trying to go slow.
Need my stuff? Oh, I'm so sorry.
So the circumstances are the guy does not state that his wife was a drug dealer when she was a juvenile. And the defense argues that was because they asked, anybody who's a drug user or dealer or whatever. And he doesn't say her. And the court specifically said the question was asked in the present tense versus
Let's double check my spelling. Colin Boyette and what? Enriquez? Colin Boyette and what? Enriquez. Oh, okay.
You're lucky you. I was going to get you really and take it.
It's like,
Oh, it is? Okay. So this is probably your last lunch period. You have many?
yes.
Yes. You probably know all the good places, as I do not.
Actually, didn't even have any lunch. Had to get checked out of a hotel.
I'll print it because my writing is. Look good.
Yes.
What are we looking for? Exhibit book.
These microphones are new, aren't they? Are these here? Better watch what you whisper.
Well, I was struggling a little with clearing my throat, but I didn't avoid coughing.
This is much more like the appeals.
Much more what?
This is much more like the appeals where they pepper your questions.
Yeah,
And they
right.
get to stick in their script.
So this is where the real action is. Tell it. The trial stuff. I mean, that's just setting the table. It's unfortunate when they make movies about all these cases, they never focus on the appeals. It's just your trial lawyers. You get all the credit. It looks like we get to do some more briefing.
to say that we don't have those particular issues, but
If you answer them correctly, you'll get better. I'm just saying.
I will do my.
Okay. No, it's fine. I don't know if she meant the statement or decision, or if she used another one.
I took it as more brief.
That's what I took us too. Is there anything else to say? I mean, we haven't covered the cases from the early 1800s.
Well, I think it's because it's brought up stuff that hasn't been raised before, so.
Important to know where it is. Exactly.
Yes, decide the darn case. I'm with you. Does red mean it's on?
Yes.
Okay. To me, red means it's on.
Wait, you think red is off?
Red is on.
Yeah, red's on.
Can you take us to three?
We got theater tickets?
We did just get the tickets yesterday for To Kill a Mockingbird, which is coming.
Oh, where?
Coming to San Francisco. Isn't the Orpheum maybe, or the Golden Gate?
saw it, got lucky. I saw on Broadway with Jeff Mason.
Yeah, Julie did too, my wife.
Oh, yeah.
She loved it.
Yeah, it's really good. It's a different twist.
I know. I know the production.
Oh, maybe I'll have to check it out. Let's go to the Berkey rep line.
Want me to move over? I can give you plenty of room.
Okay, yeah.
I might as well just move this so we get that out of his way. Yeah. Are you sure? He's definitely near him. Okay. Because we could put it up there by the.
Oh, look at that. Put that up on the screen, that'll melt some hearts.
That's who the breeder was going to put down. Can't get over that.
Fraction.
What's that?
The fraction.
Yeah.
If you don't look back, you never have to worry. See how the finance grace was here, you could always hear it. She was always talking about it.
That's what she was going to do.
Or might be. Maybe me. Maybe not.
once.
Almost done.
Yeah, silly as if I run out of ink.
So I was bringing two. I think.
You want me to? Is that it?
I could just order one more box of these.
I've read enough letters from you by
I
now.
have a bunch, I don't know, but I asked Lori, can you have Daniel order a box for me? I might not use them all for 4.5 months, but that works pretty well too.
She chose the answer that she wanted instead of the way it was asked.
I have no idea what that is though. Where I got it.
Here, like this.
Yeah. I must have been there.
Okay, folks, please remain seated, come to order. Court is now in session.
All right, thank you. We are back on the record in the habeas, in re Scott Peterson habeas petition. Mr. David Harris,
Thank you.
you may continue.
Your Honor, the court this morning had also suggested that the people answer some questions as we go through this. So I wanted to, before I go back into the argument, answer some of those questions if I may. The
All
court
right.
had asked a question about whether the past or present tense of the question, form of a question makes a difference. And we had cited in one of our briefings the Henderson case, and within the Henderson case is a subsite to a case called People versus Majors. And that's 18 Cal 4th 385 at page 420. In that particular case, a juror was asked in his questionnaire about whether he knew someone who was a drug dealer. And he responded no to the question, the form of the question, but it turned out that his wife, when she was a juvenile, had been involved in somewhat of that activity. As part of the evidentiary hearing, he had testified that he didn't know that, he didn't know her at the time that that happened. And so the court said, quote, more importantly, question 51A was clearly phrased in the present tense. We cannot fault Moore's decision to respond to the question as it was phrased. So you do have a case that's very specifically responsive to the court's question about the tense of the question makes a difference because the person is not necessarily being incorrect or false or erroneous or lying if they're treating it exactly as it is written and as that particular court found. The court also asked in a completely separate issue about if there was in the record any evidence of the race of Mr. Whiteside. So we would point to the court to exhibit number 8.
I did find it.
All right.
There's 8, and then there was, I think it was 13.
Well, specifically just for the speed of the record, Exhibit 8 has the face sheet, which is from the East Palo Alto Police Department, which has the arrest information for Mr. Whiteside, which does include a box indicating his race.
Okay, thank you.
Also, one of the other questions the court was talking about and potentially suggesting future briefing dealing with about the definition in the past of what harassment was. So we wanted to try and address that now based on the slide that was presented. That particular slide was quoting from CCP 527.6, and Mr. Gardner had explained what harassment meant, and there was an indication that the inference was that it was unlawful versus the tort versus the crime. So as what I was seeing on the slide that was up on the particular screen is the slide said, after the first part, which could be potentially criminal, it said, or knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses. So even under that definition that's provided from that section, that doesn't necessarily mean criminal conduct. So we make that distinction for the court because as we go through and talk about these incidents, we have the lawsuit, which the petitioner does tend to take that and create that going from a lawsuit to that conduct being criminal in nature as well. And as we pointed out repeatedly and Ms. Nice has testified to, she did not view that as being criminal behavior. It was a civil proceeding. It was not criminal. She could have called the police and she didn't. It didn't happen relating to that. So going back to where I had left off, specifically Ms. Nice had testified when she had completed the questionnaire and talking about the restraining order or anything else, it didn't cross my mind. When questioned, even though you were in the same courthouse that it happened, Ms. Nice explained, yeah, it didn't cross my mind. I just don't hold on to things. I didn't remember. It didn't cross my mind. Ms. Nice further elaborated saying, that was over. I don't hold grudges. It was past me. And that's back in Reporter's Transcripts, page 84 through page 85. Now, one of the things that the court can take from that particular exhibit, when we were looking at the Exhibit 1 dealing with the restraining order, is that's the first example that the court has physical proof Ms. Nice is not very good at filling out forms. She was specifically asked on that particular exhibit, who did you put down as your attorney? And she was asked on page 259 of the transcript, in that particular document, you filled out, looking up at the top of the box where it says, attorney or party without attorney, whose information is written in there? And she puts Marcella's. And did you write that in there? Yep. Was she your attorney? No. So we have, even before she ever comes in with that little summons for jury service that she put on her refrigerator, proof that she has a tough time filling out forms. So she put the wrong person in the wrong place for something that was in that particular record. Was she lying about that? Was it false? It's wrong, but there's no intent on her part to really try and say that Ms. Kinsey was her attorney. She just filled the form out incorrectly. Counsel was talking about how that process of the restraining order, kind of dovetailing into this, was a crime, and she should have reported that because the circumstances of the events that led up to this. So I just want to take another quote, and this is from the Reporter's Transcript at page 47 to 48. Ms. Nice testified, okay, so had Marcella not continued to bother me, so this is after the September incident, I would have never filed a restraining order based on these facts. So since she did, I did add that in there because I knew it was showing history of her being a little stalkerish. So I put it all in there. But again, had she not continued after that day, this day, if you see the restraining order was filed a couple months later, if she had stopped, I would have never filed a restraining order. So as the court has already mentioned, the circumstances of Kinsey showing at her ex-boyfriend's house is one particular incident where the people's position is Miss Kinsey was not I'm sorry, we just had a screensaver pop up there. So she's not a victim in those particular circumstances. It's the additional conduct, the fact that she continues to be bothered by Miss Kinsey, which is what causes her to get the restraining order. It's not based on claimed criminal conduct that happens in September. And again, dealing with I know the court had asked the question, and I had addressed this before lunch, the difference between the first civil restraining order and the potential possible suit, the second issue. Regardless of that, Ms. Nice was asked about the Marcella suit being dropped, and I recall dropped being the language that she used several times in her testimony, and we pointed out in our briefing because that's consistent with somebody wanting to drop criminal charges. She stated that when she completed the questionnaire, she never thought about it at all. So again, that's the Reporter's Transcript 302. Now, so we have this background information. We talked about the law. has the petitioner met his burden of shifting the circumstance, shifting the burden to the people to prove that there is a rebuttable presumption that Ms. Nice had done something wrong. And part of that argument that they say the court should look at, the totality of the picture, as they were trying to say, is because of certain things that she lied, she was granted immunity, and the court kind of raised those, or talked about those issues. But one of the things that we want to point out, and the court has already mentioned this, but we're going to give you some additional law on this particular point. The court had said one witness is sufficient to prove a particular point. Now, early on in briefing, the petitioner had said, well, you really can't trust a juror. You know, how can they say that they shouldn't be, they can't say that they weren't biased. You just can't really go there. So we're going to start by talking with the U.S. Supreme Court's case of Smith versus Phillips. In that particular case, the court rejected that very argument that the trial court cannot possibly ascertain the impartiality of a juror by relying solely on the testimony of the juror in question. So you have that particular case that says you can use that juror to decide whether they're telling the truth or not. And that's what this evidentiary hearing was about, is for Ms. Nice to come in and explain how she answered this questionnaire all these many years ago. Now, the Smith case is not the sole case. We also cited in our briefing the People versus Cochran. And in that particular case, one of the cases cited by the defense relied upon them heavily is the Diaz case. And the Cochran case said, we, unlike the court in Diaz, take the statements of the jurors that they could set aside this knowledge, and in this particular case of a family, and judge the case fairly and impartially at face value. We decline to evaluate and subsequently dismiss such statements by jurors as self-serving, as did our colleagues in the Diaz case. Going further into more recently, in the Cowan case, Supreme Court said the referee was entitled to credit the juror's sworn testimony at the hearing on this point versus other unsworn hearsay statements of the officer's report. And that case is assisted in this particular circumstance because in that particular case, the petitioner had subpoenaed one of the involved officers in their issue. That officer was sitting in the courtroom, but they never called the officer to testify. Yet they referred to police reports and other things, and they didn't put the officer on the stand. So in this particular case, what we have, counsel referred to them as these, the contemporaneous documents. But as the court will recall, you've now just looked again at Exhibit 8, which is the face sheet. That is not a contemporaneous document. Ms. Brackshire testified to that particular document being generated 20 years after the fact. And in fact, when she talked about it, there's a box on there that says when it's generated, and it was 2022. She talked about how she was not sure how that information even ended up in the system. Somebody had to put it in there. She wasn't sure. You recall her testimony about these particular documents and where they came from. So those contemporaneous documents are not very supportive of the petitioner's position. They've relied constantly on an accusation that was filed against Mr. Whiteside. They talked about the complaint. Here's all the things he was charged with. It would be so nice if it was easy to prove just by referring to the complaint that somebody was guilty because they just filed the complaint. It would make my job a whole lot easier if that's all that I had to do. But we know that's not how it works. And in fact, all of those charges are irrelevant because Mr. Whiteside didn't plead guilty to any of them. There was an additional count that was added, and he pled no contest. As the court will recall, we had that discussion throughout the evidentiary hearing, and that was the end of it. We would be required to speculate at best to figure out why Mr. Whiteside, assuming what petitioner is saying is true, why he might plead guilty if, in fact, he was innocent of the charge. Again, the people could come up with lots of different reasons why that might be, or the fact might be that he really was guilty and he took a deal that was offered and that was the end of the discussion.
So his plea was NOLA, right?
Correct.
Is that significant? And if so, why? Versus guilty?
The only thing that
Go ahead.
legally it makes no difference. As Pat Harris pointed out, the code section that says for all purposes, from legal purposes, the fact that it's NOLA or no contest makes no difference. It's still treated as being guilty. That's the standard instruction as part of a plea the judge would read to that individual. However, the reality of dealing with criminal cases, we know sometimes defense attorneys will talk to their clients and say it's a no contest plea, you're really not admitting it. Again, we're getting into the area of speculation, which we'll keep reminding the court, we gain nothing by speculating when we have the facts before us in this particular case.
All right.
In this particular case, what we do know is that Ms. Nice came into court, the only witness on this particular point that came into court. She addressed this particular issue, and she said he didn't do it. So that's the evidence before the court. And again, it doesn't matter because the question, as she said, she didn't think about this particular issue, but the question wasn't asking whether she would have been a defendant or she would have been arrested. It was completely different, and we're going to go through that in just 1 second. But to be clear about this, the Cowan case is significant. This also came up during some of the testimony. The Cowan case, the referee was entitled to credit the juror's sworn testimony, said the officers, as I mentioned. And the fact that the juror in question did not remember that they had been fighting in public did not cross his mind was sufficient by that particular denial for the referee to find that there was no misconduct. The court had addressed the issue of immunity, so I just want to add one note to that particular area. The California Supreme Court in the case of People versus Lucas they've addressed this about witnesses wanting immunity. And the quote from that particular case is, "Innocent persons as well as the guilty are entitled to invoke the privilege. As the High Court has declared, the privilege serves to protect the innocent who otherwise might be ensnared by ambiguous circumstances." So again, we have the law saying you can't look at this immunity. Ms. Nice could have been asked, why is it that you need this? But the mere fact that she asked for immunity is not something of substance that helps the court get to any particular place.
Well, how do you address the fact that Mr. Gardner raised that, she all of a sudden stopped cooperating? So she spoke to the Habeas Corpus Resource Center investigator in 2015.
Correct, and I think the circumstances there, to use the example that Mr. Gardner used, is when he was citing to the Manriquez case, he talks about it's one step forward because the person volunteered in that particular case. But the fact that the person doesn't step forward does not mean that they're taking a step back. The failure of something is not necessarily a negative. So in this particular case, what we do know is Ms. Nice gave statements, did interviews, and in 2015, when one of the Habeas Corpus Resource Center investigators showed up, she talked to them. She gave them a statement, and we went through the whole issue of the notes that she used to review, refresh her recollection. There was no declaration that came with it, so we're not exactly sure what was said, but we had the notes that she could figure out the date from. From that, she learned that she's being accused of misconduct, potentially that could result in a new trial for Mr. Peterson. We know that the information becomes public after that, as Mr. Gardner indicated, was filed as part of the petition. It's reasonable for a person to get a lawyer if somebody's accused. That's what happens these days. Anybody who's accused of things, they get a lawyer. Lawyers give them advice of what to do. To speculate why those things happen, again, going back to, we're speculating. What we do know is she talked to them when she wasn't being accused of wrongdoing. Once she's accused of wrongdoing, her obligation by law, because the Hamilton case says jurors have a statutory right to refuse an interview. She didn't have to talk to them. She has an obligation to come to court when she's subpoenaed and testify truthfully. That's it. So this is not a negative against her. It may not be what they want, that they could have deposed her or talked to her or had many more interviews, but it doesn't prove a negative. It just
Well, to get to the point about depositions, Mr. Gardner and company did ask the court for leave to depose Ms. Neese, I believe it was Ms. Neese, her mother, Mr. Whiteside, and the people opposed the motion. The court denied the request. but, you know, you're bringing this up now, well, they could have done this and that, but the people took the position that I shouldn't allow the discovery.
And we still have that position because the reason, as we explained at that point in time, is this court needs to sit and watch Ms. Nice testify because you're the determiner of whether she's credible or not.
Well, what
So-
about Mr. Whiteside?
In that particular case, you need to see him as well, that based on the claims that they were saying he was going to come into court and say, he needed to come in court and say.
Okay.
So one of the things, I point this out, there's the case of People versus Henderson. The Henderson case is a circumstance where the Court of Appeals, in that particular case, at 78 Cal. 5th, 530, in this particular area is at 563 and 564. A juror in that particular case ended up, I think it was in a coffee shop, sitting next to a defense lawyer who was not part of the trial but knew who was involved in the trial. There was some brief, innocuous conversation, but that attorney brought it to the court's attention. The court brought in juror number 2 and they had a discussion. The juror, when asked about what was said, didn't recall what was said. And the court immediately went to thinking something, presuming, because the fact that he didn't remember it, that it was bad. So the Henderson case says that under the demonstrable reality test, courts may not presume the worst of a juror.
Slow down when you're quoting for the court reporter, please. Thank you.
So I'll repeat it again. And the court was not entitled to do so by presuming the worst. Such a presumption, however well motivated, does not furnish the good cause required by the governing statutes. So thus the trial court erred in excusing the alternate in that particular case. Because the fact that the witness may not remember something doesn't get you to the point of saying that the witness is lying. Now, if the court would have found them to not be telling the truth, that would be something different. So that's when the petitioner shifted, saying, well, immunity is one thing. Here's all these statements in her declaration. So let's go through her declaration and say where she's making things up. First, we want to start with, the court will recall the beginning of her testimony. She was asked about her declaration pretty much paragraph by paragraph by Pat Harris. And it was, is this true? Is it true and accurate? And she would say yes. But she got to particular points and she would say, not so much, or something's wrong with that. And she ultimately said that there were some paragraphs that were wrongly worded. And so she wanted to correct those particular paragraphs, and she did as they went through it. Now, to answer another one of the court's questions about how the exchange worked, where she was doing this declaration. She testified at reporter transcript 222 that when preparing this particular declaration, it's with COVID, it was a bit hard. When you don't get to meet with somebody in person and everything is done over the phone or Zoom, so I think a lot of things get mixed up. And I probably should have sat down in person with this attorney, but everything was done over the phone, Zoom, and emails. And that's, quote, specifically at reporter transcript 300, line 3 through 12. So you have the witness explaining to you, here's the process, the declaration is created, I sign it, I should have maybe gone over a little bit more to make sure it's clear, but as we go through this, is it true and correct? I'm going to tell you where I find some mistakes as she's reading it. And that's what she's doing. She's clarifying her declaration. Again, she's not lying. As things, as she said, as things were explained to her, as things became more known to her, she would say, well, maybe not that way. Maybe it should have been this particular way. However, one of the things that she did clarify, and I think this is of significance because it shows the honesty of Ms. Nice, is one of the paragraphs she corrected, and this is page 33 in the transcript. She said, before the trial, I didn't have any anger or resentment towards Scott at all. After the trial, it was a bit different because I sat through the entire trial and listened to the evidence. And because of that, she said as to paragraph 31, it was wrongly worded as to not having any bias after the trial. And she explained that. So again, the fact that she corrects and clarifies something does not necessarily mean that she was lying before. It just means that she may not be articulate, or she may not have completely understood, just like her jury questionnaire. She was not alone with having that problem. The court will recall Ms. Bracksher's and the conversations I had with her. Ms. Bracksher's produced 2 separate declarations on exactly the same point. One declaration, she testified that she was the person who created the document. And this is a woman who had 10 years of experience as the custodian of records. This was her job. She's received training in how to respond to subpoenas. And then she submitted a second declaration where she said it was Officer Corpez who was the person who created the document. And more illusory or illustrative of this particular issue is the fact that both of those declarations were prepared for her by the Habeas Corpus Resource Center. So you have 2 documents covering the same grounds that are diametrically opposed. So it's unlike what Mr. Gardner was saying, there's a chasm between some of Ms. Nice's answer. This is an impossibility between Ms. Bracksher's. But we're not saying that she's a liar. She said, I didn't really understand, but she did testify the second one, Officer Corpus's, that was more accurate. So if we were to look at the circumstances of the credibility test that you were being asked to apply to Ms. Nice, and you applied that to Ms. Bracksher, the court would have a lot less evidence. We're not saying that that's the case. We're not, like I said, we're not saying that she lied. We're just saying that she didn't completely understand. And in Exhibit 9 is the SDT that was submitted by the Habeas Corpus Resource Center for the East Palo Alto Police Department. And it asks for any and all documents, whether electronically stored or otherwise, related to the November 2nd, 2001 arrest and prosecution of Eddie Whiteside III in case number EO1-306-17. This request includes documents stored in electronic databases and specifically the multi-agency RIM system. Now you'll recall Ms. Bracksher's testimony, and the court's already looked this morning or this afternoon at the attachment to Exhibit 8, which is the face sheet. She testified when you submitted the subpoena under penalty of perjury, you turned over one record that existed for the Palo Alto Police Department in response to the subpoena. Is that correct? Her answer, correct. And that was page 518 of the transcript. So you have her telling you there is only one document. Except the unfortunate problem was she was shown other exhibits that came from her system that she printed out. And those were exhibits 23, 24, and 25. So we talked about that with her. And she was asked at page 534, did you have additional conversations after the subpoena with the attorneys? Answer, yes. Where you started to think over maybe you should have turned those things over? Answer, well, what they asked me for was to do the screenshots of each page that we had information on. And so that's when I presented the screenshots to him. And that was because they received, I guess, something from the DA's office that had screenshots. And that's when they asked me if we had anything that we could provide, if we had that. So that's when I provided it. I didn't even think that I needed to do that at first. Question, it just never crossed your mind to submit those particular items to them? Answer, no. They just asked for reports. I printed what we had, which was just a face sheet. So you have a trained expert witness dealing with her area of expertise who gets it wrong, doesn't comply with the subpoena, submits not all of the records that she should have because it just never crossed her mind. She didn't think that that's what they were looking for. The people don't submit that Ms. Bracksher is lying. We submit that she did the best she could based on what she thought was being requested. There is no difference between what she did and what Ms. Nice did with her jury questionnaire back all those many years ago. It just never crossed her mind. She was mistaken. So, excuse me. So petitioner wants the court to say, okay, forget that there might have been mistakes. The fact that she said that she was spiteful, there's the bias that comes out. So again, we would submit to the court the fact that petitioner is just jumping right to the bias is a concession on their part that, assuming that they have met their initial burden, which we still don't concede that they have, it's been rebutted by the testimony of Ms. Nice, who said, I didn't think about this, these things never crossed my mind, I did the best that I could, even though I'm really bad at filling out forms. So now we have this circumstance where, oh, she was spiteful.
I'm sorry, did Ms. Nice say she was bad about filling out forms?
I'm sorry, that's my
your-
quote, yes.
Correct, she never said that on the record.
I'll just show the court the evidence of her being bad at filling out the forms.
All right, but there is a distinction that's
Yes.
important. All right, thank you.
So the petitioner uses the word spiteful to Ms. Kinsey. So in the transcript, the reporter's transcript, that particular word, spite, is used 8 separate times. Page 52, page 53, page 195, 296, and 297. The problem with it, again, goes back to the questions about the case where the judge couldn't take the coffee shop conversation about the juror and instantly go to a bad place. There was never a follow-up question. There was never a follow-up question that said or asked, was it not true? Was it false? Was it not truthful? Was it not accurate? Was it a lie? Instead, it was spiteful. You can be spiteful and still be true. So again, it was incumbent upon the petitioner to follow up those questions and find out if in fact they were a lie. Just because you want to assume that it is does not make it a lie. And as I said in the Henderson case, you can't presume the worst. Now the court did mention the circumstance of where Ms. Nice had contacted somebody from law enforcement about seeing the video. So that was, goes to page 194 and 195 where she explains that particular thing. And there was an interesting conversation that came in that particular line of questioning where Ms. Nice was asked, was the restraining order for both you and your unborn child? Answer, yeah, but he was born at that time. Okay, question. And so you understood that. Well, let me ask you, did you understand that once your child was born, the restraining order was over? Answer, no, I still had the restraining order. Question, restraining order was over for your child? It no longer applied? Answer, I don't know. I'm not a lawyer. I don't know. So during this particular time period, Ms. Nice doesn't even really know, it appears from what her testimony is, whether that restraining order is still valid or not. She just was spiteful at the moment and contacted somebody because she saw Ms. Kinsey with your child in this video.
There's nothing in the record that indicates that the police were called up. She contacted someone, but there's no record evidence that there was a phone call made to 911 or
Correct.
anything like that. Okay, thank you.
So the next area that the petitioner has tried to claim that here's proof that Ms. Nice was lying is they have marked as an exhibit. It wasn't discussed this morning, but I want to just touch briefly about this because it's significant for another reason, and that's exhibit number exhibit 16, dealing with the child support issues.
Just a moment, please. Okay, I did not, at the time, Mr. Gardner, correct you. She didn't file for child support. It's the Department of Child Support Services that they're the attorney on the document. But you would agree?
I do agree, Your Honor.
Okay, thank you. Go ahead.
So that particular exhibit has 2 separate requests or under 2 separate case numbers where there is a filing for child support. And the reason I bring this up is because there's 2 additional circumstances in those particular documents showing that Ms. Nice is not very good at filling out forms. That's the simplest way to put it. There was one that she discussed when she was on the stand, and that's dealing with question 5E, where she put down that she had spousal support of $400, and then she said something to the effect of that she never had spousal support. She filled that out wrong. And that's on the reporter's transcript, page 117. So that was one that we know about, where she's saying, she's filling out a form, but she's got it wrong. There's another one, Exhibit 16, question 19C.
Just a moment. What page? 4?
Unfortunately, those are not numbered, and there's 2 separate case numbers under that exhibit.
So 19C is the special hardships expenses for minor children? Is that the one?
Correct. And
Okay.
the C question is, these expenses listed in A, B, and C create an extreme financial hardship because, and then in parentheses it says explain. On both of those particular forms, Ms. Nice did not answer the question. So once again, even though she's claiming something with relating to that particular question, she didn't explain it. So I bring this to the court's attention because this is the second and third time in the record that we have Ms. Nice not being able to complete a form correctly. These are matters that have nothing to do with Scott Peterson. These are matters that relate to complete different issues, different courts, different subjects, showing that, like I said, she's just not very good at filling out forms. The court has already pointed out a couple of additional things in her questionnaire relating to this particular case, where she just wasn't good at getting the answers down. But there's no showing at any point in time that she is lying about this. There's no showing. And there's a fine line, we discussed this in some of our original briefing, between intent, falsity, and lying. What is really meant by that? What we're saying is that she's wrong. And I would disagree with Mr. Gardner about this when it comes to the chasm of distance between whether something is false or whether it's erroneous. The fact that it may not be completely accurate doesn't mean that it's a lie. If she's doing the best that she can, but she doesn't know how to fill out a form, or she makes a mistake, doesn't make her a liar, doesn't show that she is intentionally doing anything. Which takes us back to Manriquez. Manriquez basically said an unintentional violation may be sufficient to overcome the amount of prejudice by itself. So now moving on to the second question, the more nuanced question as Mr. Gardner was talking about, which is question 74, whether Ms. Nice was a victim or a witness in all of these multiplicity of things. I'm just going to go through this really fast because the court's heard a lot about this. I disagree with Mr. Gardner when he's talking about a first-year law student in a door, whether she's a victim or not. Again, this wasn't her door. As the court indicated, she testified that she went upstairs when this incident happened. She told Eddie that somebody was outside for her. So she did not see this particular circumstance happen. It's not her door. It was her landlord's door of her mother's house where her mother is on the lease. So if we wanted to stress it further to say, well, anytime that somebody in the house, you could be a victim too, or you may have known something, that's a little bit far. Does it make it reasonable when she doesn't put that down in her questionnaire? The tires. She specifically was asked that particular question on page 56 of the transcript when she thought that Miss Kinsey slashing the tires would be a crime. Miss Nice responded, it wasn't a crime against me. They weren't her tires. She didn't see it. She wasn't there. Stalking. Again, we could spend a lot of time with that. Stalking appears in different forms 6 separate times in the reporter's transcripts of the evidentiary hearing. And it goes back to the statement I read before where she was saying she put that information to show kind of the stalkerish history of Miss Kinsey when she was applying for that restraining order, and that's at reporter's transcript 48. Clearly, she is not referring to stalking as a crime as we would define it under Penal Code 646.9, which has a very specific definition, which has years of cases that explain how that particular case or crime section should be interpreted. We have her using this in a very generic circumstances where she's talking about how Miss Kinsey followed her and made faces at her that she saw in her rearview mirror. The phone conversation. As I recall, the phone conversation is actually not in evidence. What happened was she was asked the question, did you put that in your declaration? Nobody ever asked the follow-up question whether that was true or not. So we don't know who called. We don't know how she knew it was Miss Kinsey that was calling. So we're just left to assume certain things again. As the court was indicating, there's a broad spectrum of what threats are. So then we get to the next level of what she potentially could be a victim of. When she was getting this civil order, she wasn't being threatened. She talked about that. We've covered it a number of times where she said she didn't want to be stupid and roll around the gutter when she was pregnant. She didn't say Miss Kinsey was coming out and threatening her. She said what she was saying, asking me to come out, she knew what would happen from that. That is not a threat. That does not make her a victim. So the last area...
Can I go back just for a moment?
Sure.
To Exhibit 16, the child support. It was the Department of Child Support Services that were her attorney. I understand that. But if you look at the September 8th, 2004, I mean, actually both forms, and these are forms, the Judicial Council family law forms, they're filled out every day in family law cases and support cases. But these are not Bates numbered. So on the September 8th, 2004 filing, income and expense declaration, she doesn't on this form list any spousal support from a different marriage, correct?
Correct.
Okay. And then on item 12, the following people live with me. She doesn't list her mother, correct?
Correct.
She doesn't list Eddie Whiteside, correct?
Correct.
Okay. But they did live with her at the time.
Again,
Okay, but that's a yes or no question. Did they live with her at the time?
well, actually, I would disagree with the court that it is a yes or no question because the way that the court phrased it versus the way that it's written in the question, and that's what we think is significant. Did she live with them or did they live with her?
Okay. And then going on to the next page, item 20. She writes, the question is, other information I want the court to know concerning my case.
Mm-hmm.
She says, I may be out of work for the next 5 to 6 months due to jury duty in San Mateo County. I'm a prospective juror on, or in, I can't read, a major case. What significance, if at all, does that statement have vis-a-vis what she told the trial judge about the finances are taken care of? I've talked with my family, everything's fine.
Well, I think the circumstances are, again, looking at how this plays out in terms of sequence. The first sequence we have is when she comes in to fill out the questionnaire.
Okay.
Then we have her reporting back for the voir dire where she's present with Mr. Garrigus and the judge.
So it was March was the questionnaire.
Correct.
When did she come back? Let's see, the transcript is at 5, and that is, I don't have a date on it. So you don't have the cover sheet, but it's at Exhibit 5. Do you remember when it was?
Off the top of my head, I believe that the court looks at the questionnaire. There is a date written on it.
All right, but they could have come back at different times. But it was before September 4th of 2004.
Yes.
Okay, go ahead.
So the sequence is she fills out the form, comes to court. At some point in time, those forms get filed by the Department of Child Support Services. And the court will note, because they both have separate signatures and dates, they're two separate dates. I believe they're about a month apart.
Okay. Go ahead.
So the first one, she does not make the statement about being a potential juror. The second one, she does make the statement about the potential juror, which would indicate that she's at least been through the process and she may end up being a juror. So again, she has new information, she's adding it to the form. In terms of the finance, the ultimate finance issue, the people would submit as a red herring. Because as we heard from her, Ms. Nice testified, and those documents tend to support, what happened was she got involved in some type of issue with her former employer. The former employer ended up paying her for the entire time that she was on jury duty. So there was no financial hardship. When you take things as a snapshot, you could say, well, this is different than this one, and so there's a problem, but we can see the progress just by looking at those two particular forms. First, she gets the spousal support wrong. A month later, she fixes it. She doesn't have information about jury duty, then she does, so she adds that in there. But bottom line, we see from those particular documents, she attached pay stubs that she was still getting from her employer. She testified, and there's been no challenge about this particular issue, that she continued to get paid throughout the trial based on the agreement that she reached with her employer.
Okay, so the first filing she signs on March the 26th. It's not filed until May 10th of 2004. And that's the one where she doesn't list anything about the trial, but she does put the $400 down for, excuse me, spousal support. The second one was filed on September the 8th, but it was signed, at least the signature page is April 17th, 2004. Okay, thank you.
So again, moving forward in terms of looking at her credibility as to these, question 74, the specific subparts that the petitioner has raised, dealing with the DV issue, bottom line, it was petitioner, if they are going to claim that she was a domestic violence victim, the only witness that could dispute that, based on what Ms. Nice testified to, was Eddie Whiteside. Eddie Whiteside, as the court indicated, a subpoenaed witness, didn't get called. It shouldn't have been a surprise. They didn't need to do a deposition to say, did she hit you? Or did you hit her? So we can't, I don't want to beat this dead horse, but they have to lose on that particular point because they didn't produce the evidence. It's their burden to do it, and we'll move on from there. So the next one is, if she wasn't a victim, was she a witness? The two-part compound portion of this question. Again, their burden to prove. They talk about, she spent a great deal of time on the stand about whether she was a witness because whether you hear it or not hear it. And she said she had gone upstairs. She never saw the door kicked or saw the tires slashed. In fact, the quote is, when Miss Nice and when Kinsey's cousin knocked on the door, and here's a quote, and they asked for Eddie, and I shut the door and went upstairs. I told Eddie he had a visitor. And that's at Reporter Transcript 182. Miss Nice stated, that was 100 years ago, so I believe that's when she started yelling for Eddie to come outside. Reporter's Transcript 88. Miss Nice never went downstairs when Miss Kinsey was yelling for Eddie to come outside. Reporter Transcript 88, line 22 to 24. So she did not see the door get kicked. And she's asked specifically at page 64, line 19, when you checked no, did you have a different understanding of the phrase witness as to the slashing of tires, crime of slashing of tires? Answer, I didn't witness her do it. Question, okay. And that's my question is your understanding of witness that you actually have to physically see something? Answer, yes. Again, this is Miss Nice testifying what her belief was, what her understanding was, and there's no showing that she's actually wrong. We can have a disagreement about that, but her interpretation is not unreasonable. So even if she should have said something because she didn't view it that way, that she's not wrong. And there's a number of cases that we've previously cited that say that particular point for jurors. And I think it's significant because in her voir dire with Judge DeLucchi and Mark Garrigus asked a particular question. This is at page 4223, Exhibit 5, asking about whether there's some issue with their children, her children, and somebody comes running to you first. And her answer was at line 6. Answer, yeah, if I don't see it, I don't. Whoever comes running in tells me first, if I don't see it, I don't go with that, no. So even back when she's being selected as a juror, she's explaining her position that if she doesn't see it, she's not a witness. That doesn't make sense to her. And it explains the second and last portion of the witness aspect, which is the incident with Eddie Whiteside. she thought that that particular circumstance, she was asked about this, and the court may recall the particular question, were you outside of your body? Did you see this particular? And she's responding, no. In her mind, she was not a witness to this. She was actively involved. She couldn't see it, so therefore she wasn't a witness. And again, it may seem silly, it may seem different, but it's reasonable for her. The whole incident for whether she was a witness for, because she's alleged to have made the phone call on the Kinsey incident. And as we pointed out, our position on that is that she is a reporting party. She's not a witness. She's just calling something in because she believed that Whiteside told her to. So again, addressing all of those particular issues, the only thing, so her being a victim or a witness, there's no showing and there's been no proof by the defense, by the petitioner, that she actually was either a victim or a witness in these particular circumstances. Now, whether family members, which is the last component, the last compound portion of question 74, were victims or witnesses or family members a victim or a witness. So the circumstance that we have is we have Eddie Whiteside's tires get slashed. We've already gone through this where she says she did not see what happened, she didn't know what happened, she didn't follow through and participate in the particular criminal proceeding. That was another question that she was asked later on.
But she put it in her restraining order.
Well, she put in all of the facts in 2000 when that happened.
Okay.
And she also wrote it in the third person. That was part of the questioning that was asked as well. So the fact that she may have been told something to add it in there does not necessarily make her, she's not a victim or a witness, she's being told, and the people will submit, maybe she should have been aware that he was the victim of this particular tire slashing, of something that happened several years beforehand. But this is where the reasonableness comes in. The fact that, assuming that that's true, that she should have thought about that yeah, his tires got slashed a few years ago by the ex-girlfriend, I should remember that, to put that down. You heard it from Ms. Nice, it didn't cross her mind. She doesn't think about those things. So was that a reasonable response for her to say, I wasn't thinking about something that was such a past incident. She doesn't hold on to those particular things. And I think that is reasonable when she says that she just never thought about it when she filled out her questionnaire. She's been unequivocal and steadfast in repeatedly denying any intentional withholding information. So that takes us to kind of whether the burden has been met by the defense. And I want to talk to the court about the Hamilton case, which is referring to the McDonough case. In that particular case, Hamilton's referring to McDonough, saying that to invalidate the result of a lengthy trial because of a juror's mistaken though honest response to a question is to insist on something closer to perfection than our judicial system can be expected to give. Even more recently, our Supreme Court, in the case of People versus Wilson, in this particular case, 2021 case, a juror forgot to mention that she had previously served on another, what she said was a capital murder case. So she's sitting on a new capital murder case and forgot that she'd been on one before. And that court said whether juror number 9's undisclosed prior service was a capital trial or a murder trial is beside the point. When assessing whether it is substantially likely a juror was actually biased, our inquiry is not whether the juror would have been stricken by one of the parties, but whether the juror's concealment or non-disclosure evidences bias. Juror number 9, inadvertent non-disclosure of her prior jury service did not evidence bias, and said the trial court was correct in denying the new trial motion. In this particular case, there's been no showing by the petitioner that Ms. Nice has done anything other than make mistakes. So, assuming that they met their burden, Ms. Nice's testimony her declaration, and the entire record before the court has rebutted that particular presumption. So then it moves to the next phase. If the court wants to give them the benefit of the doubt and go to that particular point, it then becomes their burden, once the presumption is rebutted, to prove actual bias. And so I'm going to try and wrap this up real quick into what they've said about bias. The bias comes from her finances, that she was fixated on the little man, and that's based on the book, the letters, and Ms. Anderson's statement, and also that there was a preconceived verdict in this particular case. So just to go through these really quick. As we've already said about the finances, that's just not accurate. It's rank speculation because we know from the testimony that's not disputed, she got paid her entire time. Ms. Nice testified that when she made the statement to the court, it wasn't a lie. Mr. Whiteside and her mother were aware that Ms. Nice would be bringing in a very small amount during jury duty for money, and that's at Reporter Transcript 122.
Can you slow down, please?
And again, had the petitioner wished to dispute those or disprove those particular points, it was incumbent upon them to bring in Whiteside as to those particular issues, the mother, or even in the case where they asked her, did you borrow $1,000? They could have brought in the juror that they claimed had loaned her the money. So again, going back to her finances, we've already talked about the income and expense declarations, unrelated matters to this particular case. They can't show her bias in this case because there's no connection. So moving on to the book.
If I can, for a moment, these letters. The exhibits, let's see, we have, just a moment. Six, seven, no. I think they're all exhibit 6.
6 and 6A.
They've been admitted for state of mind, right?
Yes, looking at would cite the court to Reporter Transcript 388 for the court's ruling on that particular point.
Okay. How, if at all, should the court consider those letters?
Well, first, I think we want to start with the circumstances of the letters. Ms. Nice testified that her therapist was the one that suggested that she write those, and that's, again, citing to the record at 253, lines 13 through 19, and 295, lines 4 through 8. These were written after the trial. So how did these letters connect back to, in fact, as part of the court's ruling on page 388, so the court indicated there was an objection because it's the state of mind, it's an issue. But again, I'm admitting these. You preserve the argument, Mr. David Harris, that the respondents do. The court should give very little weight to these letters. This is the discussion that we had when these were coming in. These are after-the-fact letters written at a suggestion from a mental health professional based on the issues that Ms. Nice was going through at the time, based on the evidence that's before the court. There's nothing in there in any of those letters that say, hey, by the way, when I was filling out the questionnaire, here's what I did. Mr. Baratlis testified how other jurors were impacted in this particular case, a murder case. So those letters do nothing other than kind of help share that anguish that Ms. Nice had gone through. And the court knows this because the court will recall she testified that this case had changed her. She broke down on the stand at one particular point. The court took a break. Court put on the record later on that she had been tearful at different times during her testimony. So again, this is all before the court based on that information.
All right.
So again, just going back to the book briefly, because that was submitted as two separate things. One is to her bias and one is part of her financial points. And I just want to sum it up at best. When the court looks at Exhibit 3, the particular book, Reporter's Transcript, page 305, there was an objection, and the court asked, is there an exception to the hearsay rule? So page 305, starting at line 1. At line 1, Mr. Pat Harris, yes, it's not offered for the truth. In fact, we would dispute the book has any truth to it. So under these circumstances, it's tough to argue how this book is going to be helpful to the defense to prove any particular point. And we would point out when it comes to the financial motive,
You
There-
mean petitioner?
yes,
Okay.
it'd be difficult for the petitioner to prove that there was a financial motive on the part of Ms. Nice because there were 6 others, if I recall correctly, jurors that helped write this particular book. They never asked Ms. Nice what windfall was she going to expect from writing this book. So the follow-up question, which would have proven the point, was never asked. All we know is that after the trial, according to her testimony, somebody approached her and asked if she wanted to participate in writing the book, and she did. The one thing that, from looking at the book, there was a conversation that was had with Ms. Nice where she was read, did you say this in the book? She was read this particular quote, and this is at page 284, lines 26 through page 285, line 3. We gave Scott the fairest trial he could have. He was innocent in all of our eyes until the evidence proved him to be stone cold guilty. So if we were to submit the state of mind based on what the book was, again, that would be something that shows Ms. Nice did what her job as a juror and based the case based on the evidence. So going into the last particular components, because little man and preconceived verdict come together. There is really no evidence before this court of this whole little man thing other than she may have said that term at different points in time. We have the stipulation about Ms. Anderson that in 2017, she saw a photograph that had a juvenile with something on the clothing that said little man. We don't know anything about that. We don't know who it is, where it is, how it got there. We don't even know if it's the picture that comes when you buy the frame.
Well, that's why I asked about the letters. She uses the term little man in the letter.
Correct.
I'm not sure, again, where I can't point my finger to, but it is in the letters, right?
Correct. There's no denying she uses. She testified during the evidentiary hearing, but the claim that she's fixated because she used that particular term, there is no evidence of that. So then again, the petitioner tried to take that and connect it to the verdict, to the jury deliberations, to show that it was some preconceived notion on her part. And what they said, as the court talked about this earlier, is when Greg Baratlis testified. So again, we have the juror who was there, who said she came in after the juror was substituted, so she's the alternate coming in to take their place. It was never a quote. He said it's something like, and she came in and sat down when she was seated at the table. We've already pointed out, we cited to the court the Bradford case, which says that what she did wasn't wrong, and in fact it's not even cognizable because that's part of deliberations. What she's doing is going and discussing the particular case, and the facts show that she did continue to deliberate with the other jurors, and they reached the lesser verdict as we talked about before. Now the court, I want to go back to one last thing before I wrap this up. The court had pointed out page Exhibit 4, the questionnaire, the education issue, where Ms. Nice, on her own questionnaire, couldn't answer the question correctly whether she had training in medicine. So this is again her, and she's not trying to hide this. So we can take away all of the petitioner's argument about she's hiding this to get on the jury, because she answered the very prior question, I'm a medical assistant, I'm a CNA. And she answers the question just before, beneath that, I've got medical and nursing training. It's once again just an example of her filling out forms badly. But she's, as you pointed out, question 97A, she also got that one incorrect. And the people would submit to the court when Pat Harris asked the questions about the mother and father, and there were just question marks in those answers, and the court stopped him. I believe Ms. Nice did testify that she doesn't know when her mother was born. There was also another question, the why question, that related to her brother being in prison. So this information about her inability, or however you want to put it, to properly fill out this form was before all of the parties at this point in time, and Mr. Garrigus had that form before he stopped her leaving the jury box. He wanted her there with her bright pink hair and a mother who did methadone treatment training and a brother that had been in San Quentin for drug convictions. The only thing that we can show is that after all this, Miss Nice is not really good at filling out questionnaires. She made mistakes, she forgot about things, but she did the best that she could. She wasn't hiding anything, which takes us right to a long list, and I'll just go through this briefly. We start with the Cowan case we've already talked about, where the juror said that they weren't hiding anything. Fields versus Brown. In that particular case, that's where the husband didn't tell the court that his wife was raped in a rape special circumstance murder case. And his wife believed the defendant in that case was her rapist. The defendant didn't bring that to, or excuse me, the juror did not bring that to anyone's attention. She gave a declaration to the defense, and it goes on and on. Information bearing on Hillard's testimony in voir dire, impartiality as a juror, came up after he was in panel. The evidentiary hearing by the district court afforded Fields an opportunity to show that the person was not fair and impartial. He failed to do so. The opportunity to show actual bias is a sufficient remedy and a guarantee of the defendant's right to an impartial jury. That's what this hearing was with Ms. Nice, and the petitioner has failed to show that she was not a balanced, reasonable, impartial juror. Another case, the Headland versus Ryan case, and again, these are cited. That court disagreed that you cannot possibly ascertain the impartiality of a juror by relying solely upon the testimony of the juror in question. Court disagreed. Boyette, that was discussed by counsel. That particular case is significant. Again, another, I believe it was a death penalty case where the foreperson, besides having some of the jurors watch American Me, the video, to find out what prison life was like, failed to disclose his prior several felony convictions, misdemeanor convictions, family member convictions, and the court found that the non-disclosures were not intentional and deliberate, that such non-disclosures were therefore not indicative of juror bias, and that Ari was not actually biased against the petitioner. The failure to recollect was not intentional or deliberate. The Cowan case, the fact that the person did not try to hide anything on their questionnaire and did not try to answer the questions in a manner that he believed would increase his chance of being selected on a juror. This is a circumstance where the juror forgot to put something in their questionnaire about being arrested at a mall years before, and the court found in that particular case that the petitioner must prove by a preponderance of the evidence the facts that establish entitlement to relief. And the fact that Cowan argues that the juror intentionally omitted his misdemeanor conviction so that he could serve or be selected as a juror, lobby for a conviction and death sentence, and thereby earn goodwill with the district attorney in the event he violated probation or sought early termination in his probation. This theory, however, is speculative and contrary to the evidence. Much like what the petitioner is claiming here, that she wanted to get on this jury to get Scott Peterson for some unknown reason, for some unknown financial motive. Manriquez, we've already talked about.
Well, the reason, and Mr. Gardner, you can correct me, was that she wanted to get on the jury to punish Scott Peterson for the death of the baby. That's one of the reasons they've articulated, correct?
That's the attenuated claim after you have to go through a bunch of hoops to get to that particular point. But again, we submit to the court, there is no foundational elements to even prove the basis of those particular claims. That, going back to the McDonough case, which is the U.S. Supreme Court, McDonough Power Equipment versus Greenwood. Supreme Court talking about what you must do. Party must first demonstrate that a juror failed to answer honestly a material question on voir dire, and then further show that a correct response would have provided a valid basis for a challenge for cause. The motives for concealing information may vary, but only those reasons that affect a juror's impartiality can truly be said to affect the fairness of a trial. one of the cases that we cited to before, but we think this is important for the court to look at this particular case, and that's the San Nicolas case. It was mentioned by Mr. Gardner this morning. In San Nicolas, a juror was arrested for drug possession. He wrote a declaration for the defense after the trial saying, I didn't tell you that I had this pending case, and I had agreed to work this particular case off. However, more importantly, this particular juror, when he was 12, neglected to include when he was 12, that he had been the victim of a crime of being stabbed 15 times. He still had scars on his forehead, and his ribs were broken when he was a minor. None of that stuff was admitted, and this was a case where both of the victims were stabbed to death. In that particular case, the court said the proper test to be applied to unintentional concealment is whether the juror is sufficiently biased to constitute good cause for the court to find under Penal Code Section 1089 and former 1123 that he's unable to perform his duty. Whether a failure to disclose is intentional or unintentional, and whether a juror is biased in this regard or matters within the discretion of the trial court. Except when bias is clearly apparent from the record, the trial judge is in the best position to assess the state of mind of the juror or potential juror on voir dire. And they refer to the Peters test. And the last case was the Wilson case, which we talked about the juror forgetting that they'd been on a capital murder case before. Ms. Nice is much like that particular juror. She forgot a few things. She didn't put them in her questionnaire. There's some debate. We're having a legal argument discussion about whether something is a lawsuit or whether she has to hear a crime or see a crime. The burden has been on the petitioner to prove the material nature, material relevance, and the clarity and the specificity of the questions that were asked. The presumption of prejudice is rebutted going back to Hamilton, and the verdict will not be disturbed if the entire record of the particular case, including the nature of the misconduct or other event and the surrounding circumstances, indicates there's no reasonable probability of prejudice, no substantial likelihood that one or more jurors was actually biased against the defendant. Meaning that the presumption can be rebutted by showing the misconduct was unintentional or due to inadvertence, lack of memory. And we've already talked about a single witness, which Ms. Nice was, proves and rebuts any of those presumptions. But there is one last thing that, when you look at the Cochran case, the Cochran case talked about here the evidence of guilt was extremely strong, and we conclude that the presumption of prejudice has been overcome by the circumstances and content of the non-disclosure as well as the strength of the case. So I would cite the court to the case of People versus Peterson, where our Supreme Court found, and the trailing testimony aside, there was considerable other circumstantial evidence incriminating Peterson. From the simple fact that Laci and Connor's bodies washed ashore 90 miles from their home, but within sight of where Peterson admitted he went fishing on the day that they disappeared, to the research Peterson did on bay currents in the weeks preceding her disappearance and the fishing boat he bought but mentions no one, to Peterson's inability to explain what he was fishing for in the middle of the day, to his repeated subsequent surreptitious trips to the marina in the weeks after her disappearance, to the many steps he took in the weeks after she went missing, selling her car, exploring sale of the house, turning the nursery into a storage room, that indicated that he already knew Laci and Connor were never coming back. Even under the most stringent harmlessness standard for federal constitutional error citing the Chapman, it is clear beyond a reasonable doubt exclusion of the limited dog-trailing evidence admitted by the trial court would have had no impact on the jury's determination of Peterson's guilt. In this particular case, it was the petitioner's burden to prove, his burden to produce the evidence. There's an old saying about accusations fit on a bumper sticker. Truth takes a little bit longer. In this particular case, we ask the court to follow Shakespeare. Do not cast away an honest man for a villain's accusation. We ask the court to make the required factual findings, deny petitioner's claim number 1 and discharge the OSC. Thank you.
Thank you, Mr. David Harris. Mr. Gardner.
Yes, Your Honor.
Oh, Madam Court Reporter, do you need a break? Okay, so we're going to take a 10-minute break, please. We'll be back on the record at 3 o'clock. Thank you.
Thank you, Your Honor.
So we were trying to figure out, found it, more deer was unfortunate. Sort of in the midst of the DCS system.
I know something happened because she wrote it in the second that she was going to be a jerk.
I feel like hearing some of those just like it.
With the exception of the families, we're going to clear the courtroom, okay? Media and public, right? For 10 minutes. We're going to clear the courtroom for 10 minutes. With the exception of the families.
It's been longer than I thought.
I think you did a very fine job.
Trying to keep me timed or didn't work. I ran out of time.
Yeah, you did start talking faster than I did.
Well, that's because I knew I was having to clear it up.
That's when the outfits were up. I really understand because the Laci just
I don't know about because there's a lot of it. So Victoria, how much did I miss? You said you have my notes. Were you following along with them?
No, I have actually.
I did
No,
skip
I
over.
wasn't following the notes. I did have them printed and available if you needed them.
No, I had like 6 or 7 more cases, but it took me a while to stop.
There's no such thing as going too long if you're covering what needs to be covered.
Where's the point in time or... I thought we had a couple of Zoom ones, but then again, it's Zoom
Yeah.
TV.
You didn't stop anything.
she's living with me. What's that?
Or did she want you to respond how it was about Instagram?
I had to text myself. I must do this strong word in this. I did it.
Thank you.
Is that your screensaver? It's okay. It was just the screen's black and all of a sudden that pops up. I'm like, what is it? It's architecture of some kind.
It's one of those revolving ones. You end up with something. You're like, what the heck is that?
At least once I figured out what it was, it's like, okay, I can ignore it.
So you're gonna ask Mr. Gardner for batteries again?
I feel like I should request a restraining order. Will you be my attorney?
Is it a lawsuit?
I've been a victim of
Are you a victim or a witness?
I want to say, the whole courtroom witnessed it.
No, I need a ride from one of you guys with my suitcase to Miriam's house, which is 7 minutes from the airport.
Okay.
So I'll go to the airport and drive to here with her.
What's her name?
Well, she was a high school classmate of my dad's in South Moment Center.
Oh, how wonderful.
Very sweet lady. Her husband was a well-known OBGYN here locally, delivered a ton of babies for years. He was a very funny guy. Her friends that moved, they were friends of his. He was in Minnesota. Hired an ice company or somebody to come in and spray a whole bunch of snow in their front yard. So he did a lot of pranks. He's a sweet guy.
Yeah, what a huge change. Minnesota.
Wow, I didn't even know when they moved out here.
talking too fast.
Yeah.
Well, my timer ran out and I still had stuff to cover, so then you start speaking.
I know. Do you know who this little lady is that sits back here? He's shaking something and making noise. Did you hear that? Because she said to me outside, "Do you remember me?" I'm like, "I'm sorry, I don't." She was shaking something. It was like rattling, which is right when he was talking, and then the court reporter couldn't hear. Yeah. Huh. Is she a little? Maybe that's why you. Yeah. Right. Oh wow.
No.
Fighting. Yeah. Feet feel better?
We can sit down now. But she's got the padded chair. You've got it rough because you've been sitting in the hard chair the whole time. For telling Gardner that when we first started, we were in this courtroom. And all of the chairs were hard like that. After a few days, it was just killing her guts in her back. So they brought in actual padded chairs instead of just having pad. It was nice. One of those chairs?
Because the newer chairs can't put a file on it. No, actually, I think it ended up in my office because when one of my staff was somebody moved their chair and put a wooden chair in there.
Mark Smith brought it back, and they made their way around the office.
But now my Brenda actually got a very fancy chair in her office, so now I have two pretty fancy chairs, and the old-fashioned ones like this, they last forever. And nobody wants them, so they don't come here.
said it was over my line, so you know if you
Was it
wanted-
over? No, she doesn't know.
Oh,
I know, I got the same email from somebody, yeah, getting on the customer. Got a fashion survey for the county. So there's one
Oh,
from
bully.
CEO Operations and Services, there's like 7. And then this is from our controller. It's like, oh my God.
It'll be for a long time. I was one of them. So all of them. Maybe make this
So if we're logged in for a little bit anyway, 10:15 is what I'm watching now. But protest this morning. Protest in front of our doors. This is routine now. This is regarding an officer-involved shooting case that happened recently. As of now, there are 45 people, and it is peaceful. Coming and going. We do not engage with them.
My apologies.
Demo.
He was better than that first guy. Man. Thank you for that. Here I am standing here for no reason.
They say
I got nothing to do.
the YouTube thing says we're not starting until 3:10.
Oh, YouTube says that?
Yeah, apparently. I didn't even know that was a thing, but I said maybe because they're trying to figure out the tech issue.
Okay.
Your protest we don't deal with.
If YouTube says that?
Yeah, nobody deals with it, so.
I can't believe you're on YouTube.
I know. I got a message from somebody who's watching the stream. It says the YouTube says it will continue at 3:10. Ah. YouTube knows more than we do.
That's why I say we're going to.
Nope,
It's in
I'm
this
good.
one, stay with
I got-
You can put me on there.
How you doing?
Find something reasonable to watch.
No,
We have a
you
chance to visit.
got the funny dog and cat.
If we can visit with you after. Yeah.
It's like there's a John Burns spot. One of the ladies needs behind it. Trying to glue herself to the floor in a basketball player. Trying to drag her off the court. Yeah. They were rough. The one thing that wasn't good is they helped sedate them, so they put into
Can you look up Feast of St. Crispin's Day and see if that was going to be the first one?
Say that again?
Feast of St. Crispin. St. Crispin's Day speech. Let's put St. Crispin's Day speech. See if it's from here.
I mean, that's- We're trying. What's the quote you wanted?
We would just, can you search for cheaply?
Right here. And older man who's cheap.
I'm gonna talk about holding you cheap. It's a stretch, I know.
But he's got shirts, I think, so he's gotta get out of here soon. I'm making a joke with Mr. Gardner, he didn't hear me.
I'm sorry, what was it?
What a joke. He said, yeah, he's got shirts with it, so he's gotta get out of here soon.
I was gonna say something. I do love the people, but I don't have tickets tonight.
So if you're a theater fan,
Yes.
although I don't want to interrupt you, but
No, that's okay.
what's your take on the revival of what?
Have you seen it?
No, but they just switched over, so you know the show.
Yeah.
She's she's always been well, of course she did over Streisand. She's no and she's a great soul singer too. So she wanted to get to some because she had some social media phone calls with people.
Really?
But they just gave it to her and bumped her up. So now she's starting beginning of September. She's gonna
Oh, she'll be great. She'll be great.
Me and Michelle, she was in Glee. She played Rachel. She actually did 2 of the shows from Funny Girl during the Glee show, and she killed it. Not that I would admit that I know anything about musical theater.
That you would watch early.
Pardon?
we're back on the record. Mr. Gardner.
Thank you, Your Honor. I know I have 20 minutes. I know I have a problem with speaking too fast, so I'll try to accommodate both of the competing concerns.
All right.
I want to respond to a number of the points my colleague, Mr. Harris, has made. And in discussing whether we've carried our burden of proving misconduct, he pointed out that there's nothing in Exhibit 1 that would have alerted Ms. Nice to the fact that this was a lawsuit. In fact, although it was undoubtedly unintentional, that's not right. As bad as Ms. Nice may be in filling out forms, apparently this shows that lawyers aren't particularly good in reading them either. Because here's a picture of Exhibit 1. This is the very first page of the exhibit. Petra, can you put that up? This is the first page, and let me just focus on that very first sentence. This is the petition for harassment. And if you could focus in on that, Petra, with the next slide. Actually, I can't even read that. Let me read it here, Your Honor. Read the instructions for lawsuits to prohibit harassment, Form CH-150, before completing this form. Now, of course, Ms. Nice filled this form out herself. She's a layperson. And I know, even as a lawyer, when I fill out forms, I take care to read it. I suspect as a layperson, she took even extra care to read it. We'll talk in a few moments about her inability to fill out forms. But this isn't an inability to fill out a form. This is apparently an inability to read the form, because the form says it's a lawsuit. Counsel suggested that with respect to the civil damages, Ms. Nice was somehow vague. And I know earlier on in this morning's session, I showed Your Honor and called Your Honor's attention to pages 42 to 43 of the transcript. I'd like to call Your Honor's attention to page 291. This is the last slide we were able to put together in the few minutes we had for preparing rebuttal, Your Honor. And this is what page 291 says. This is Mr. Pat Harris, but you sued her, did you not? I filled out paperwork. And you filed them with the court, correct? Yeah. And you filed a lawsuit against her, correct? Yeah. And you knew what a lawsuit was, is that correct? Yeah. When I was suing her for money. So again, Mr. Harris points out that there's no documentation. But again, I'll remind the court, the burden on a petitioner is not to prove documentation, it's to prove the facts by a preponderance of the evidence. This unrebutted testimony satisfies our burden by a preponderance of the evidence. Mr. Harris points out that we did present paperwork in connection with the temporary restraining order, and the restraining order litigation that's some 20 years old, and he says this paperwork should have been available too, although it's from a different court, Santa Clara versus San Mateo. And all I can say to that point is that with respect to my colleague, Mr. Harris, he's clearly never prepared a habeas petition 20 years after the fact. Oh, that it were so, that documents remained low these many years later, but that's not how the real world works. Sometimes the documents are gone, and it's just that simple. I wish he was right that we would always have access to all our documents, but it isn't the case. Mr. Harris repeated or doubled down on the suggestion that one of the reasons Ms. Nice did not answer that it was a crime was because it was not her door. He doubled down on that. And I didn't have time to prepare a slide, Your Honor, because we only had 10 minutes, or we only thought we had 10 minutes. But I'd like to call the court's attention to page 31 of the evidentiary hearing transcript. And this is Ms. Nice answering the question of if she knew what happened to Ms. Kinsey after the incident. And this is what she says on page 31, lines 10 to 12. On whatever date it was, when she came to my house, kicked in my door, after she left there, I don't know what happened to Marcella. Ms. Nice knew this was her door, not the landlord's door. This idea that it was the landlord's door is a post hoc rationalization that's been offered for this court's consumption, but it doesn't reflect the reality of what Ms. Nice was thinking then, and it doesn't reflect the reality, as we talked a little bit about this morning, about what a reasonable person would believe when their door is kicked in. Excuse me, Your Honor. Mr. Harris this afternoon made the point that, yes, Mr. Baratlis testified to what Ms. Nice said at the beginning of deliberations, let's get him for what he did to little man. And he made the point, citing Bradford, that it isn't misconduct. And I want to just be clear. I made that point in our initial brief. I made that point this morning. Our claim is not that it's misconduct. Our claim is that that statement gives an insight into the state of mind. And that's the relevance of that testimony, as it's the relevance of the letters, for example. It's an insight into the state of mind.
So unlike Mr. David Harris, you do think the letters are relevant?
Yes, in terms of state of mind.
Okay.
Counsel made the point that Ms. Nice was just about to be discharged, and she had walked several chairs down, and Mark Garagos stopped her. And that's true. But I'm not sure what the relevance is, because here's the scenario Mr. Garagos finds himself in. He has this jury questionnaire that she's filled out. He may like the answers. I think Mr. Harris said one of the reasons. Thank you so much, Your Honor. I think one of the reasons Mr. Dave Harris suggested that Mr. Garagos wanted Ms. Nice on the jury was because of her red hair. I think that was a quote he said this morning. Maybe. But the point is, when he made that decision to stop her and say, Judge, you didn't even ask her if she's willing to serve, despite not being paid, he had the questionnaire with the false answers in front of him. That isn't someone who wants this juror necessarily on the jury had he known everything he now knows. In fact, we have an unrebutted declaration from Mr. Garagos that had he known about this TRO, he would never have permitted this juror.
Well,
and that's,
okay, but so I agree, but as the court pointed out, he also had before him in a jury questionnaire 97A. She checked she couldn't be fair, and with the pretrial publicity, he never even followed up. So yeah, he didn't have this information that he said would form the basis for a challenge now, after Mr. Peterson is found guilty. But at the time when he had information indicating some bias, your position is that was a mistake.
my position is that any trial lawyer would look at that and say, that's a mistake, she just checked the wrong box.
Okay.
Otherwise, you would pursue it in questioning during voir dire. No one would permit that juror if you genuinely believe that was her answer.
Okay.
On several occasions, and I don't know what I could have said to suggest this, but I want to make sure I didn't. On several suggestions, my colleague, Mr. Dave Harris, said that I have conceded we have to prove bias. I've not conceded that. I didn't mean to concede that. If I conceded that, Your Honor, I made a terrible blunder, because it's not our burden to prove bias. It's our burden to prove misconduct. And at that point, the burden shifts for the state to prove the absence of bias. My colleague has suggested that Ms. Nice is not good at filling out forms. And he's pointed out some areas of the forms where she was incorrect. Well, she certainly had plenty of practice at filling out forms. We have the child support payments in March, and we have the child support payments in April, and we have the jury questionnaire, and we have, of course, the paperwork. You asked a question that related to this, and I'm not sure you got an answer. The question was, in the financial affidavit, why did she not list Ms. Cosio, the mom, and Mr. Whiteside as living with her, when, in connection with the jury voir dire, where she told the judge, yes, I have significant others, I live with my mom. Why the conflict? Why, they're both under oath. Why didn't she which answer is correct? You didn't get an answer. I don't have an answer either. I just point out the fact that you asked that question and you didn't get an answer as to that conflict. One explanation, of course, is that she was seeking different things. In the child support, Your Honor points out that she didn't bring the child support action. That's true. But in the child support action, she's seeking funds, so it may be wise to understate who's living with you. In the jury voir dire context, if you want to get on that jury, you have to show that it's not going to be a financial burden. And so there are different motives. That's one explanation. I know you didn't get an explanation this morning or this afternoon. We also, again, on the same point about filling out forms, on the very first page, it's actually I-7, but the first page of the petition for prohibiting harassment, and I don't have a slide on this, Your Honor.
That's all right.
It's I-7, Exhibit 1, page 7 in the lower right-hand column. It has a file stamp of November 27, 2000 in the upper right-hand corner.
Okay.
And it's entitled Petition for Injunction Prohibiting Harassment. I think
7 by close of business, is that the box?
it's actually I-7 in the lower right-hand column in someone's handwriting. Not mine, because you can actually read it.
All right, just a moment.
It's actually the 7th page of the exhibit, at least in my binder, Your Honor.
Okay, just a minute. Seven, plaintiff. plaintiff has actually suffered. Is that the,
It's actually I-7 in the lower right-hand column in someone's handwriting. Not mine, because you can actually read it. It's actually the 7th page of the exhibit, at least in my binder, Your Honor.
just a minute. Seven, plaintiff has actually suffered. I'm sorry.
I'm sorry, Your Honor.
These are not bait stamps, so it makes it difficult. So
Okay.
I'm going from the first page, which is the certificate of records.
I'm with
and
you.
I'm going back 7 pages.
Going up 7 pages, and I have a file stamp copy, San Mateo County, November 27th, in the upper right-hand column.
Correct.
Right, and under box 5, this is the
Box 5. Thank
box
you.
5, the difficult form that counsel is suggesting that there's difficulty in filling out forms. This is simply a check mark on a form, Your Honor. This doesn't require a legal education at Harvard University. Defendant has, and this is what Ms. Nice checked, threatened to commit acts of violence against plaintiffs, plural, because it's for her and the unborn baby. And then she checked committed acts of violence against plaintiffs. So this isn't some difficult form to fill out where you should have had legal advice. It's a very simple form. That check mark is either truthful under oath or it's not. If it's not truthful under oath, then we have a client who, then we have a witness who's very difficult to credit because she's lying under oath. We go to page I-11, which is the typed narrative, Your Honor.
Yes.
In the very last line, I think we covered this a little bit. Michelle does not want, this is 3 lines down from the very last, 3 lines up. Michelle does not want Marcella to be able to come anywhere near her child. After it's born, Michelle feels like Marcella would try to hurt the baby with all the hate and anger she has for Michelle. Again, this isn't filling out a form. This is a narrative that comes from your own pen, from your own heart, from your own head. The state's position is that that isn't true. Well, this isn't a form filling out problem. This isn't why I checked the wrong box. I didn't understand what I was supposed to do. This is her narrative recollection of why she wanted the restraining order. So I think it's important to understand we're not talking about simply checking boxes here and the difficulty of reading a complex legal form. This was her own personal narrative. Counsel points out that, in fact, there's case law that says you're entitled to credit the testimony of a juror. Of course you are, Your Honor. You are entitled to credit everything Michelle Neese said. You are not required to do so, however, and the question is, should you credit it? And that's why it's so important to look at the things that are said under oath in 2000 and compare them to the very different things that are said under oath in 2022 about the same subject matter. We covered some of that this morning. But the suggestion that you're somehow, you must credit the testimony, no. And to the extent there's a thought that I somehow was briefing that you can't accept it, of course you can. I just don't believe you should for the reasons we discussed this morning. Counsel suggested that Mr. Whiteside pled nolo to the simple battery charge, and that was the end of it. That's not quite true. He pled nolo, but it wasn't quite the end of it because he was sentenced to 10 days in county jail. He was sentenced to 104 hours of domestic violence counseling, and a restraining order was entered.
Well, I don't know in the record if there was CTS for the 10 days, or was it 10 days prospectively? We don't know. Agreed?
True, we don't know.
Okay.
We don't know, but we do know that it wasn't simply the end of it when he pled.
Right.
That there were consequences to that plea, consequences that he would have known about and someone living with him would have known about.
Well, again, with the restraining order, if you look at the same page that we were just at, item 4, how is it that you know the defendant? Marcella is my ex-boyfriend's ex-girlfriend.
Yes.
So we don't know what was going on with, I think Mr. Pat Harris asked the question, and Ms. Neese talked about how Eddie she's the song Papa's a Rolling Stone. And so we don't have in the record evidence whether Mr. Whiteside was living with her at the time after this incident where the police were called, or, really what he was doing, right?
I think that's fair to say. It's fair to characterize it as a complex relationship.
Okay.
We don't know. We know at some point after that they were living together again. At some point they weren't. We don't know exactly when.
Okay.
And I'm not sure Ms. Nice would know either. It sounds like it was almost a daily decision. Could be.
Could have been.
Counsel suggested that the financial motive, we pointed out, drops out because, in fact, at the end of the day, she received payment for her jury service. But, of course, that's not the time when you determine whether the financial motive made her eager to serve. The time when you determine that is when she was offered a hardship discharge and turned it down. At that point, she did not know she was going to get paid. All she knew at that point was that she had $3,800 in monthly expenses, $1,800 in monthly income, $400 in child support, $160 in the bank, and 4 young children at home. She did not know at that point she was going to receive, in fact, payment throughout jury service. So the idea that somehow it's a red herring, I believe, is itself a red herring, Your Honor. The important part is when she made the decision that I'm going to go the whole voir dire, at that point she did not know she was going to get paid. And so she had very much, there were financial concerns at issue, and her eagerness to get on the jury at that point is very relevant. Two more points, Your Honor. One, counsel suggested that the letters can be explained because it's Ms. Nice's therapist that suggested she write, and that evidence was in the record. My recollection is a little different. My recollection is that counsel asked the question, was this at the suggestion of your therapist? She said yes. There was an objection from Mr. Carr saying, wait a minute, what about the privilege, psychotherapist patient privilege? We had a sidebar. Mr. Harris withdrew the question precisely because he did not want to open up the psychotherapist patient privilege. And so that question was withdrawn. But let's put that aside. Let's say, in fact, there was testimony, and it was withdrawn because had it not been withdrawn, we would have been able to contact the psychotherapist, say the privilege has been waived, what did you talk about? So it was withdrawn for good and sound tactical reasons. I don't fault Mr. Dave Harris for that. Let's put that aside for the moment. There's nothing that suggests the therapist said, here's what you should write about. And the fact is that those letters have a number of different subjects, but the one subject they have in common is little man. That's the one subject all of them have in common. Finally, I think it's noteworthy that there is no explanation, none has been offered, for why in 2000, in filling out this paperwork, Ms. Nice said, Michelle feels like Marcella would try to hurt the baby with all the hate and anger she has for Rochelle. And why in 2022, she explained that by saying, really what I was concerned about is not that Marcella would try to hurt the baby. She wouldn't try to hurt the baby. The baby might get hurt with us rolling around on the ground. Counsel disagreed with my suggestion that there's a chasm between those. I'll stand on that. I think there is a chasm between those. There's no explanation for that other than what we talked about in some of the briefing is the surgical precision of the evolution of Ms. Nice's testimony.
Okay, going back to the letters for a second. Would you agree with me in looking at the letters? She, Ms. Nice, never once says to Mr. Peterson, shortly after this trial was over, you deserve everything you get because of what you did to little man. She never uses those words, does she?
I don't recall her using that phrase, Your Honor.
And she never expresses hatred towards him in these letters, correct?
Correct.
Okay. And as a matter of fact, in one of the letters, she says the verdict was not based on hate or emotions.
Yes.
So how should the court consider those statements that are made shortly after the verdict?
Sure.
If at all, again, you know,
Sure.
it's state of mind, so how would you suggest the court?
And let me make clear, my statement that it was should be considered for state of mind may have been too broad.
Okay.
There's a specific state of mind I'm talking about, and the concern here has always been, this is a woman who was assaulted when she was 5 months pregnant and sought a restraining order because she feared for her unborn baby's life. The concern is that she's going to bring that history into evaluating the evidence against Mr. Peterson. So when I say the letters are relevant to the state of mind, I'm talking about the focus on Connor, the focus on little man, being a central focus of Ms. Nice's concerns about the case. Not a broader state of mind, but I'm talking specifically this. Now, Mr. Dave Harris might want it in for some other purpose, but that was the purpose that I believe it's
Okay.
relevant for.
All right, thank you.
And let me just say this. Mr. Harris, as he's wont to do, because he's a very articulate advocate, ended with a reference to Shakespeare. And he undoubtedly knows Shakespeare much better than I do, or at least he's not old enough to actually know Shakespeare, but he knows his writings, of course. And let me just say this, that we have in this case, Your Honor, we have, it was the landlord's door, there were Eddie's tires, my mom signed the lease, I was not a victim because I never testified, Eddie was innocent, the police charged him with endangering and cruelty to a child because my lip was bleeding. These are just minor indignities, and on one hand, I'm concerned about my baby because of all the hate and anger that Ms. Kinsey has, and on the other hand, I'm simply worried we'll roll around on the ground. She would never try to harm my baby. I think the record of Ms. Nice in answering questions under oath and in providing information under oath in Exhibit 1 shows, if I can paraphrase Shakespeare, paraphrase the St. Christmas Day speech, I believe she holds the oath cheaply. Shakespeare spoke about people holding their manhood cheap. I believe she holds the oath cheaply, Your Honor, and I do not believe that she's the type of credible witness this court can rely on to find that relief should be denied or to find that the state has carried its burden of rebutting the presumption of correctness. With that, unless the court has any questions or wants to talk about logistics or further briefing.
We can talk about logistics. Thank you so much.
Thank you, Your Honor.
All right. So what I would suggest, you do not have to, but if you wish, you could provide the court with proposed memorandums of decision. I think we talked about this the last time. It's more of a civil process that we have in civil cases. And the reason I'm doing it is to give everyone an opportunity to perhaps address in more detail, if you wish, the questions that the court raised today. You don't have to, but if you wish, the court would ask that you complete those and submit them by September the 16th, and then the matter would be deemed under submission. Does that work for everyone?
Yes, Your Honor. Apparently it does.
Okay. All right. And when you do so, please provide them on a, no, it's escaping me. A
Electronic format?
thumb drive, thank you. On a thumb drive in Word format for the court. All right?
Separate and apart from filing them?
Yes.
Send the court a thumb drive.
Thank you. All right. Anything else? I'm sorry.
We were discussing just logistics. Is the court asking both sides to submit separate to the court?
Simultaneous, yes.
Yes. All right. Thank you.
I'm sorry if that wasn't clear. I apologize. Okay. Anything else? Mr. Gardner?
No, I'm sorry, Your Honor.
That's all right. Mr. David Harris?
No, thank you.
All right. Thank you so much. We're adjourned.
So we'll talk to Scott now for a little bit. Dave, we're gonna go talk to Scott. It's good seeing you. I guess we won't see each other again.
Probably not.
Good luck in your retirement.
Thanks very much.
Enjoy, we'll see you over the next few years, I'm sure.
You never know.
No, you never
Okay.
do.
Jonathan went away to 2 weeks.
Yeah. You don't leave the stuff you want to talk to Scott. Please don't look through it.
By the way,
Yeah.
we were incorrect. Later on with Pat Ferris,
Yes.
we asked the question, she says the same thing, there's another question. So unfortunately, there was a question and answer that came in for the second last time.
I'll look at it.
We double checked.
Okay, I'm sure you're good.